Oh, very poor. We can versus
or retrospective date as may be specified in the order as per the need of the.
So you see, as per this, prima facie it appears that not more than 1 year.
My lord, I have a list of cases wherein, my lord, even in the 7th year, they have given this extension, my lord. And
The
these are-
government,
Government in pursuance to writ petitions filed by this honorable court, my lord. I have a list and my friend is appearing in those cases. And this
he's
issue, my
shaking
lord,
his head.
this issue is now in session in that batch of matters. This honorable court had directed them to produce the records, how the act came into being, the statement objects and everything, and the matter is in session, madam.
Where is the order? This is just your type,
No, my lord,
type
these
sheet
are
by-
just, my lord, I've said that these cooperative societies were granted extension. Pulavadi.
No,
Lord,
you said after lapse of 5 years, but where
Lordship.
is it shown that on the 7th year they were allowed?
Lordship, seventh year, they were given their extension, my lord.
Where is that order?
I'll give the orders. And my lord's order is also there. I'll place that also. But
No, you see, the question is this,
Lordship.
130A, just when you just look at it,
Lordship,
it appears that extension cannot be given beyond 1 year,
there is an or, my lord.
whatever it may be.
Lordship.
This is just a prima facie.
Lordship.
It's not a final decision.
The first part says 1 year. Yes, madam.
That's all. It doesn't say beyond any. Let us see.
And page 71, my lord, would
Page 71.
the order. This
Yes,
is it will list to some more about this.
let us see.
My lord, page 71. One is, my lord, I have moved file to this.
Let us see the facts of the case in page 71.
My lord would come to 72. The petitioners are elected board of directors of so and so, represented by their respective presidents. The petitioners or society, my lord, can leave so and so stipulate that if family is not, my lord, in the middle. 1, 2, 3, 4, 5, 6, 7, 8 line. My lord. In the present case on hand, the term of both of the board of directors was supposed to be expired on 16/5/2020. The petitioners were fully prepared to hold the elections and adopted resolution to hold their respective elections on 5/5/2020. But the respondents did not give them necessary permission to hold the election due to imposition of lockdown for so and protocols thereof. The respondent number 4, invoking the provisions of 41(6) of the so and so, while impugn orders dated so and so, dissolved both the board of directors on specific finding that non-holding of election was due to pandemic and subsequent non-receipt of permission.
Correct. So, but then you see,
Lordship,
now this order has been passed
Lordship.
prior to completion of 6 years.
No, madam, 5 years,
No.
6 years.
6 years.
6 years is the maximum extent, and this
Correct.
came in.
That's what I'm saying.
This came in.
Now you're coming to this court after 6 years.
No, I am here regularly in this court, madam. This is not the first writ petition I have filed, and there is an interim order
No, you
operating.
just show me one order
Lordship,
whereby the government has extended that term under 130A
Lordship.
after 6 years has expired.
My lord, I can place that.
You
I
place
can
that.
place that on record. Wait, my lord. I can place that close on record. It's there, my lord, because in this case, my case, my lord.
Since it's there, please show it to me.
My lord,
The problem
they
is
are
that you know about it, I don't know
My
about
lord,
it.
actually, my lord will not have a knowledge about that. But in my case, my lord, there is an interim order operating till date.
In your case.
In my case, that is, my lord would find it.
No,
at
but
the-
then that would relate to the facts therein.
No, my lord, same issue. That I was not allowed to hold the meeting, and then I came up.
Now, so if there is an interim order
Lordship.
in an earlier case,
Lordship,
then why have you come here?
because, my lord, they have issued this order by which, my lord, they have dissolved my body. My lord. And my lord would see.
Despite there being
My lord would see 100 and I have already initiated a contempt procedure.
118.
My lord. And see
18.
the ground for that.
118.
L18. Peruse the letter of assistant registrar so and so. It appears that the following cooperative societies under Dubri subdivision are not able to conduct AGM and election as per provision of so and so due to COVID-19 and due to High Court matter for which these societies have attracted automatic dissolution as per section 39 of the Act. And my order, my lord, would find at page 77, my lord. '77 onwards, it's there. 78, my lord, 9/3/2022. Till the next date fixed. So and so the respondent in the corporation department shall not take any coercive action against the petitioner. Now that order, my lord, was further extended at page 80. Then my lord would find the order, how the matter progress. 80, interim order shall continue. 82, my lord, this is important. The issue involved is interpretation of so and so, which has been incorporated in the so and so regarding period of exemption so as to regularize various cooperative societies. The need for introduction of this section is the ongoing pandemic, during which the annual general meeting, which is required to be held every year in accordance with so and
No,
so.
okay, this is March last year. Then what happened?
Then, my lord, the matter was further considered, and my lord would come to page. My Lord Justice Monish Chaudhary's order, page 103, my lord. While issuing notice, this was continued. And thereafter, my lord, what we did, my lord, at page 105. Those matters are pending. There is around a batch of petitions.
No, maybe a batch, whatever. That is not the issue. The issue is we'll have to see the law in reference to a particular case. The period under the period or the term of the board of directors would be different. You see, 103 you said, no?
103, my lord. That's
And where is the case number?
Case number, our case number. My
Yes.
lord, page 88.
Page 88.
Lordship, no, sorry, my lord. If our case number is at page, I'll just place it, my lord. Page 95. And your lordship, this list that I have given, I can also produce an order. I can also produce the orders one.
No.
Here, you open.
No. Yes, Mr. What to do?
Well, I will go little slow.
Huh?
I will go little slow.
Yes, no problem. No, you go slow.
Yes,
It's good for me.
right.
At least I'll catch up.
Yes, well, I would point out some provisions of, well, the Cooperative Societies Act, which is very relevant for the present purpose. Now,
You see, instead of the law, the problem is the interim order that is there in the other case. Now that is going to be a bar. It appears for you to take any action. Now, if I am going to hear this matter, can this matter be decided independently without hearing the other matter, the earlier matter?
independently,
How can I?
I'll satisfy your lordship.
Okay.
My lord, directly I'm coming to your lordship's query, my lord. Now, his entire case, my lord, raised on page 78. The last part, my lord, till the next date,
Yes.
the respondents in the corporation department shall not take any
coercive-
coercive action. Now, this is an expression, my lord, any coercive action. Now, your lordship will consider that this is capable of being interpreted in a divergent way.
Hmm.
And your lordship will interpret in a manner which is in consonance with, my lord, the constitutional mandate. There is a constitutional mandate also, I'll come to that. As well as, my lord, the statutory prescription. Any interpretation which is made contrary to, my lord, the law is liable to be discarded. Otherwise, my lord, it would have anomalous result and it would lead to absurdity, my lord. Now, before that, my lord, I would satisfy your lordship, my lord, that the argument of the writ petitioner is misconceived. There are two reasons for it. Firstly, my lord, a cooperative society is required to hold, my lord, annual general meeting under section 39. Your lordship will take note of it. section 39.
Order now, you.
Yes,
This is yearly, my lord, AGM.
okay.
This is one requirement. There is a legal fiction. If, my lord, it is not held, it will stand automatically dissolved. There is a deemed dissolution. This is one provision. The other
Which stands dissolved? The board of directors.
board of directors, the board stands dissolved. This is one provision. Lordship will take note of another provision, my lord, section 41(2). 41(2) says that you need to hold the election before expiry of the 5 years period from the earlier date of election, so that the outgoing board can hand over to the incoming board. This is, my lord, another requirement. Now, my lord, the consequence of not following this mandate is engrafted in 41(4). My lord, automatic dissolution. So therefore, there are two legal fictions. One under 39, one under 41(4). Automatic dissolution. This is one consequence, my lord, in respect of the board. Now, there is another consequence, my lord, which is more important and relevant for the present purpose. The another consequence is disqualification in respect of the board members.
Under?
Under, my lord, 41(8) and section 40, subsection 4(E), my lord.
Section 40, subsection
4
4.
E, clause E, saying that unless 5 years have expired, you are not eligible to participate in the election. So therefore, once they fail under section 39 or 41(2), they are not eligible to participate in the election. So your lordship sees the consequence is twofold. One with regard to the dissolution of the board, and the other is with regard to, my lord, the disqualification of the board of directors.
No, disposal from.
So if
Now your
the
lordship will kindly take two dates.
disqualification, he is disqualified from participating in the election
For 5 years.
for 5 years
If, my lord, they either fail under 39 to hold the yearly AGM or fail under 41(2) to hold the election within, my lord, before expiry of the 5 years term. I'll come to the provisions, my lord. Lordship will kindly give me, my lord, that opportunity. Now, here two dates, my lord, are important. One is election was held.
Huh?
Election was 2 dates, my lord. Your lordship will take note of 2 dates.
Yes,
Election was held on 27/8/16.
28/7/16.
28/7. 5 years, my lord, have expired on 26/8/21.
26,
8.
how can it be 8?
8, my lord, 27/8/16.
28, 27/8.
8/16.
Okay, 27/8. So 26/8/16, correct.
26/8/21.
21.
21. Now your lordship will come, my lord, to this relevant provision. I take your lordships to chapter 9B of the cooperative, the constitution, my lord. The relevant provision is 243 ZJ,
Constitution of India.
my lord.
Which article?
243 ZJ. This is relating to the cooperative societies, part 9B of the constitution, my lord. 243 ZJ. Now your lordship will come to
243.
ZJ. Your lordship will come to clause 2. Lordship has got it. Clause 2, my lord. Sub-article 2.
ZJ, yes.
ZJ, sub-article 2, my lord. Lordship has
Yes.
got, yes, my lord, I am reading it out. The term of the office of elected members of the board and its office bearers shall be 5 years from the date of election, and the term of the office bearers shall be coterminous with the term of the board. So from the date of election, it is 5 years, not beyond that. So date of the election having been held on 27/8/16, the term is up to 26/8/21. Well, it cannot extend beyond that. Now your lordship will come to 243K. This is the other requirement of holding the election before expiry of the term.
243K.
K, my lord. The next ZK, my lord, ZK, sorry. The next provision, my lord. 243 ZK.
Yes.
Now, notwithstanding anything contained in any law made by the legislature of a state, this is, my lord, the non-obstant clause. The election of a board shall be conducted before expiry of the term of the board, so as to ensure the newly elected members of the board assume office immediately on the expiry of the term of the office of the members of the outgoing board. So therefore, you are required to hold the election before expiry of your term of 5 years.
Yes.
This is another constitutional mandate. Now, the corresponding statutory provision, your lordship will find under section 31 in respect of the term of the board. Sorry, my lord, 31, yes, my lord. Thirty-one, your lordship will see, my lord.
Yes.
The term of the board shall be 5 cooperative years from the date of the election of the directors. This is a corresponding, my lord, provision. Then the other corresponding provision, my lord, to 243K is, my lord, I have already mentioned, that is, my lord, 41(2), section 41(2), my lord. May I read it, my lord? The election of directors to a board shall be conducted before the expiry of the term of the board, so as to ensure that the newly elected members of the board assume office immediately on the expiry of the office members of the outgoing board. So therefore, before expiry, you are required to conduct. Now your lordship will see the consequence, my lord, under 41(4), subsection 4. This is the legal fiction under which, my lord, the board stands automatically dissolved. Where a board fails to arrange for holding election of the directors or delegates, as the case may be, before the expiry of the term of their office in accordance with the Act and bylaws, all directors shall cease to be directors on the expiry of the period as specified under section 42(1). My lord, it should be 41(2). 42(1). Yes, 42(1) is the tenure of the board, tenure of an elected office of an elected members of the board and its office bearers shall be 5 years from the date of election, provided that the tenure of office bearer shall be coterminous with the tenure of the board. So before expiry of 5 years, you are required to hold the election. Now your lordship will see what is the disqualification. 41(8). The directors shall not be eligible for the election if so specified in the bylaws. Now, if you don't hold the election, you are not qualified to participate in the election.
Correct.
Yes. Now, the other provision I have pointed out to your lordships. Your lordship will come to section.
Is so specified in the bylaws, meaning which bylaws?
All the, my lord,
Huh?
all the cooperative societies have their own bylaws, and there is a model bylaw also which specifies, my lord. Every cooperative society.
So how is this relevant at the time? For
Yes,
the time?
well, this is relevant because section 40 is there. 40 subsection 4 is there. If your lordship comes to 40, section 40.
Yeah.
This is with regard to eligibility for a director in cooperative society.
Yeah.
Yes. Now your lordship will see, subject to such other conditions as may be specified in the bylaws, a member of a cooperative society shall be eligible for being chosen as a director of the cooperative society if. Now we are concerned with subsection 4. The period of 5 years has elapsed from the date such member ceased to be a director for the following reason. Number A is not relevant, but your lordship will come to A because they have also failed to conduct the, my lord, AGM due to the COVID. Not conducting or wrongly conducting the annual general meeting under section 39. This is one. And E, my lord, automatic dissolution under subsection 4 of section 41. This is relevant. So when there is an automatic dissolution under subsection 4 of section 41, then the board of directors, my lord, they become disqualified to participate in the election unless or until the 5 years have elapsed, my lord. From the date of, my lord, they become, my lord,
They cannot be taken.
cease to, my lord, become the directors. So now,
What
my
is the
lord,
relevance of this?
this is a relevance one. Why I say, now the interim order which is passed, if that is, my lord, interpreted in a manner so
That
that
to continue the board beyond.
my lord, that would run contrary to the constitutional mandate and, my lord, section 41, subsection 2, my lord, and 41(4), my lord. So therefore, that interim order has to be constituted, my lord, in relation to the disqualification. No coercive action means once you have ceased to be the director after expiry of your term, then the, my lord, department will not hold the election, my lord, attaching the disqualification to them. So interim order has to be understood, my lord, in respect of the disqualification, not in respect of the continuation of the board, my lord. Because not holding, my lord, the election will have two consequences. One, dissolution of the board, and the other, my lord, is the disqualification.
No, it could also mean that there cannot be a dissolution. Keeping in view, section 138.
Lordship is correct. Lordship is absolutely what I have started by saying that, my lord, it is capable of being, my lord, interpreted in a divergent way. But your lordship will not interpret in a manner so as to run contrary, my lord, to the constitutional mandate.
No,
as
no,
well as,
but
my
then
lord, the statutory prescription.
you're only confining your argument to these 39 and 41 and 40. And you're not speaking of 130A.
I'm coming to that, my lord.
Okay.
130A.
Let's go
Yes.
directly to that.
Now, in the meantime, 130A has been brought in. Now, under 130A, the maximum, my lord, the extension or exemption is 1 year.
Appears,
1 year.
appears to be, yeah.
Is 1 year. No, I'll come to that, the latter part.
Is there any decision taken by this court with regard to 130A being only for 1 year?
No such decision is taken. But what
Matter
I
is
say,
pending.
my lord,
That is pending.
the principle or the doctrine of ex dem generis will apply. The, my lord, letter will follow the former. The first part is very specific. You cannot interpret in a manner which, my lord, it runs contrary to the specific part of the, my lord, enactment. So ex dem generis, my lord, I respectfully submit, will apply in this particular provision. And when the, my lord, this provision says that it is 1 year, it is 1 year. It cannot be extended beyond, my lord, 1 year because it
doesn't say 1 year, it says 6 months, 6 months.
6 months, 6 months. If, my lord, in the first, my lord, 6 months, my lord, the purpose is served, then it is over. If it is not served, then another 6 months, my lord. This is what is, my lord, required. So therefore, my lord, if 1 year is also, my lord, given, the benefit of 1 year is also, my lord, given to them, then it, my lord, expires on 26/8/2022. Giving, my lord, the benefit of 1 year to them, it expires on 26/8/22. Now, my lord, pursuant to a division bench judgment in absolutely identical cases, now entire scenario has changed. In recently 2023, the division bench has passed an order with the same prayers, my lord. This case was filed challenging the vices of 130 capital A. Now, eventually, during the course of the hearing, my lord, that challenge was withdrawn, and the division bench, my lord, has, my lord, passed this order. The facts are identical. Could not hold the AGM due to COVID. Thereafter, 23. More date. Oh, more date to the
He's not telling you.
25/1/23.
Yes.
Number, repetition number.
25/1/23. Now, if your lordship comes to para 6, I'm reading it out. This will cover the present case, my lord.
Para 26.
Para 6, my lord.
Para 6.
These are the facts, my lord, from para 6. It is the case of the petitioner.
Just let us get the facts right. When was the election held?
Your lordship will get from para 6, my lord.
Para 6.
Para 6.
Okay.
WPC number.
Your lordship may also come to Extra copy nine to nine.
Subdivision of-
715320.
This is WPC 7153 2022.
Manoj, I am reading from para 6. It is the case of the petitioner that although the state government had relaxed COVID-19 guidelines in the state of Assam, but in spite of the petitioner society approach to the authorities for according permission to hold annual general meeting. Manoj, this is in respect of 39.
Ah.
Same Manoj, dissolution. For 1920 and 2021, the respondent authorities refused to permit the society to hold their annual general meeting for reasons based on to them. Para 7. Thereafter, by order dated 1/4/22, issued by the Zonal Joint Register of Cooperative Societies, Tezpur Zone, Tezpur, the board of directors of which the petitioner was the chairman of Bahabari Somabai Samiti Limited was dissolved. Like the present case, it was dissolved, Manoj. And one junior inspector of cooperative societies was appointed as a one-man committee of the cooperative society to manage the affairs of the society and also to hold annual general meeting within 90 days in terms of 41(6) of the Act of 2007. However, no annual general meeting of the society yet has been held so far. It is the claim of the petitioner that some of the other similarly situated cooperative societies in other districts were granted the benefit of extension of time for holding annual general meeting as prescribed under section 130A of the Cooperative Societies Act. However, the Bahabari Somabai Samiti Limited, of which the petitioner was the chairman of the board of directors, was not granted exemption as sought for. Being aggrieved, the petitioner approached this court by filing WPC so-and-so. The said petition was disposed of by order dated so-and-so, directing the petitioners to submit a representation before the additional chief secretary, Government of Assam, Co-person Department, within a period of 7 days from the date of the said order, and in the event such a representation is filed, the additional chief secretary, Government of Assam, Co-person Department, shall take into consideration the reasons and explanations furnished by the society of the petitioner for being unable to hold the annual general meeting and the election during the stipulated prescribed period under Act of 2007, and thereafter pass appropriate orders in terms of the provisions of the Act of 2007, read with section 130A, section 39 and 41(2) of the Act of 2007. The said order was directed to be passed within a period of 2 weeks from the date of receipt of such order. Para 9. Pursuant to the direction of this court in WPC 2902/22, the board of directors of the Bahabari Somabai Samiti Limited submitted the representation on 6/6/22, praying for allowing the elected board of directors of the society to hold the annual general meeting for the year 1920 and 21-22 within 3 months, and further not to give effect to the order dated 1/4/22 issued by the Zonal Joint Register of the Cooperative Societies, Tezpur Zone, Tezpur, dissolving the board of directors of the Bahabari Somabai Samiti Limited, of which the petitioner was the chairman. The deputy secretary to the Government of Assam, Co-person Department, had also called for reports from the Assistant Register Cooperative Society Mongoldoy and the Joint Register of the Society. A hearing was conducted on 1/6/22. The representation dated 6/6/22 filed by the petitioner on behalf of the Cooperative Society came to be disposed of by order dated 30/6/22 by the Undersecretary of the Government of Assam, Co-person Department. By the said order, the prayer for extension of the Cooperative Society was rejected, and the society was given liberty to submit a grievance before the register of the Cooperative Society as per provision of section 29(4). The register of Cooperative Society was directed to take necessary action as per the provisions of the Act. It was also reflected that the said representation was disposed of as per the order of the additional chief secretary of the Government of Assam, Co-person Department. Being agreed by the impugn order dated 30/6/22 and by non-consideration of the prayers for grant of extension beyond the stipulated period prescribed under section 130A, which the petitioner had prayed for due to the peculiar and unprecedented situation of COVID-19 pandemic, the present petition has been filed, whereby the petitioner has challenged the vires of section 130A of the Assam Cooperative Societies Act 2007, and for a further direction for setting aside the impugn orders 1/4/22 issued by the Zonal Joint Register of the Cooperative Societies, Tezpur Zone, as well as the order dated 30/6/22 and passed by the Deputy Secretary, Government of Assam, Co-person Department, and also for a further direction to the respondent authorities to enact fresh provisions in the Assam Cooperative Society Act 2007 or to incorporate a provision for providing the exemption for 2 periods. The prayer made in the petition by the petitioner are expected below. These prayers are relevant, my lord. My lord, read this out. Number
Why don't we
A.
see the last paragraph? What
A read
exactly
of the
was done?
certiorari for setting aside and quashing the section 130 of the Assam Cooperative Societies Act 21. This was not pressed. A writ of certiorari for setting aside and quashing the impugn order 1422 issued by the Journal Register of Cooperative Societies Testpool Zone. By this order, the society was dissolved. A writ of certiorari for setting aside and quashing the impugn order dated 13/6/22 passed by the Deputy Secretary of Government of Assam, Co-Person Department, rejecting their prayer under 130A, my lord. A writ of such nature of mandamus should not be issued directing the respondent authorities. My lord, this is not relevant because 130A. Then E, my lord, a writ of mandamus should not be issued directing the respondents to allow the petitioner to hold an annual general meeting for the year 1920 and 2021. A writ of mandamus should not be issued directing the respondents to allow the Board of Directors Fitness Society to hold their respective annual general meeting within such exempted period, that is within 39/22 and any other order. Now, my lord, your lordship will come to para 11. So the prayers were, my lord, for setting aside the order of the dissolution. Number two, setting aside the order passed by the government, rejecting their application for exemption and allowing them, my lord, to hold the election by restoring them after, my lord, the dissolution. These were, my lord, the prayers. Now, your
If
lordship
I may
will come
just
to-
come in, my lord. My friend is unnecessarily going through the whole thing. Only, my lord, will see para 15 and 16 and thereafter take a call.
My lord,
There
let
is
me-
nothing in this order.
let me
The
complete-
matter was remanded back to the government. Let my friend place before your lordship. After this remand order, what had happened? That is relevant.
Let me complete, my lord.
Just reading because it's obita, my lord. Nothing as para 15 and 16, my lord. My lord will see that.
My lord, there is a
If he
purpose
wants
show-
to just, my lord, one thing I'll make it clear, my lord. There are number of cases. Why on a pick and choose basis, my friend is raising objection? Why were these not arguments not raised in the earlier proceeding? Who says, my lord, I did not hold the meeting? I held the meeting, you prevented me. Twice, my lord. Only one extension given, second extension till date not given, my lord. I have not placed all those things, my lord.
May I
Yes.
continue, my lord?
Continue.
Yes. Then para 11, my lord. The learned counsel for the petitioner strongly urged that section 130A was inserted only to give benefit to the selected cooperative societies as have been done by the government and to deny the same benefit to other similarly situated cooperative societies like the Bahabari Samabhai Samiti Limited, of which the petitioner was the chairman of the elected board of directors. The learned counsel for the petitioner strenuously argued that such colorable exercise of power and grant of benefit on a chosen few cannot be permitted under any statute enacted by the state, more particularly in respect of a beneficial legislation like the Cooperative Societies Act 2007. The learned counsel for the petitioner submits that the same is violative of Article 19 and 14 of the Constitution of India, and consequently the same cannot be permitted to be operated, and it deserves to be struck down as being, these are relating to 130. The petitioner also made an alternative prayer to direct the state to extend the exemption of 2 years to enable the benefit to avail of the by the society for the entire COVID-19 pandemic period. Now your lordship will come to para 12. The learned standing counsel for the co-person department, however, disputes the contention of the learned counsel for the petitioner and submits that the grievance of the petitioner really is in respect of the bar of the election as a member of the board of directors of the cooperative society as prescribed under section 44A of the Cooperative Societies Act. The learned counsel for the respondent department submits that while it is not disputed that because of COVID-19 pandemic and the restrictions imposed by the state and the district administration, the procedure prescribed under the Act of 2007 to hold annual general meeting within the time frame may not have been possible for some cooperative society. It is with this above policy and to give fillip to such cooperative societies who may be facing such hardship due to COVID-19 pandemic that the legislature has inserted a new section, namely section 130A. The learned counsel for the respondent disputes the contention of the learned counsel for the petitioner and submit that the newly inserted section of 130A is not in conflict with any of the constitutional provisions, and therefore the challenge to the vires of 130A is totally uncalled for. The learned counsel for the respondent submits that the question of disqualification prescribed under section 40A of the Act of 2007, which a member of the board of directors may entail in the event of failure of the board of directors of a cooperative society to hold annual general meeting as prescribed under section 39 or special general meeting under 33.3 or the board of directors meeting under 43.3 had already been answered by a coordinate bench of this court. The learned counsel for the department refers to the judgment referred in Jahrul Islam, so and so. The learned counsel for the parties have been heard. Pleadings on record have been duly perused. The relevant provisions of the Assam Cooperative Society Act 2007 have been carefully perused. Judgments referred to have been carefully perused. Now 14, my lord, is relevant. From the pleadings, we find that the board of directors had already been dissolved by order dated 1/4/22. and an officer of the co-person department has already been appointed by the department to manage the affairs of the cooperative societies and to conduct the election within a period of 90 days. In the judgment and order dated 17/3/22, passed in Read Appeal 31/19, which is referred by the Learned Counsel for the department, we find that a coordinate bench of this court had interpreted the embargo under 44A. Your Lordship will kindly see the other prayers, my lord, has not been considered. Only in respect of the disqualification, my lord, the Honorable Division Bench has, my lord, entertained the application. Apparently, the other prayers, my lord, impliedly, my lord, that has been rejected. With regard to setting aside the dissolution of the board, with regard to setting aside the order passed by the government, and with regard to their restoration, my lord, the Honorable Division Bench had confined only in respect of the disqualification under section 40, subsection 4, capital A, man. The small a. Then, my lord, the coordinate bench of this court, after examining the provisions of the Act and referring to the definition provided in the measure like the Major Lexicon 4th edition 2010, has no specific definition of the term conducting of a meeting prescribed under Act of 2007, held that this embargo is essentially for not conducting or wrongly conducting an annual general meeting or special meeting or board of directors. This court held that in event of situations beyond the control of the board of directors and for which the prescribed meeting could not be conducted, the embargo prescribed under section 44A of the Cooperative Society will not be applicable. Such embargo prescribed under section 44A will be applicable in those cases where any such meeting, including annual general meeting, was convened but not conducted or wrongly conducted. It is submitted by the Learned Counsel for the department that no further appeal has been preferred by the contesting parties against the said judgment order dated 17/3/22, passed in Read Appeal 31/19. It is further submitted by the Learned of some cooperative societies where the grounds and reasons were found to be germane and appropriate, orders have been passed by the department. So therefore, this order is in relation to only, my lord, the disqualification part. And thereafter, my lord, after observing this, my lord, the party was relegated back to the government to file an application in respect of their, my lord, disqualification alone. And the division bench has said that once the board is dissolved, it is dissolved. Only, my lord, the consideration is in respect of the disqualification. So this is my submission, my lord. And if the interim order is interpreted, my lord, as per the argument, my lord, then it will run, my lord, contrary to the constitutional mandate and the statutory prescription. They cannot, my lord, stay beyond, my lord, the period of 5 years term. So if, my lord, disqualification, my lord, is exempted, if the bar is lifted, my lord, I don't have any.
No, but one thing, if we accept your argument, then then that 130A has no meaning.
No, in this case, my lord, no meaning, because 1 year has already elapsed, my lord. If even
No,
if one,
in any event,
yes,
according to you, beyond 5 years, they have
Cannot
got
be.
no scope to remain as a board of directors.
no, my lord, before, if they fail to, my lord, hold the election or the AGM, then, my lord, there is a provision under 130A.
Correct.
Then they can approach the government for that further exemption.
Huh.
And that has to be done within 1 year.
Hmm.
Now they are beyond, my lord, 5 years for a period of 2 years, my lord, beyond 5 years. Now it is 7 years running. Can that be, my lord? Even if that 1 year is given, my lord, the benefit to them, that can be at least 1 year. Had that been within the outer limit of 1 year, then yes, my lord, the argument would have, my lord.
That's what I said in the very beginning. That's what the query was raised by this court in the very beginning. Whether they can still continue beyond that
Cannot.
additional one.
My submission cannot go. This is my humble submission. That will be amounting to, my lord, make the constitutional provision and the statutory prescription redundant, my lord, and odious. If they are allowed to, my lord.
Carry on forever.
Yes, my lord.
And if their interpretation of the petitioner is allowed.
Yeah.
130, as per 130A, the government can carry on for 10, 20 years also.
Yes, yes.
They have
There's
carried
no
at least for
limitation.
7 years.
Huh?
They have carried for 7 years. at
No,
least.
no, whatever. But they, according to your interpretation, it can carry on forever. That cannot be the.
That's never my case, my lord. Let it finish, my lord. I'll come to that.
I finished, my lord. This is my case.
Then my lord will come to my case, my lord. Now I'll show what exactly the issue is. My lord would come to page 32, my lord.
Yes. Page 32.
32. My lord, this is an order dated 21/9/2021, by which, my lord, we were granted extension from 19/8/21 to 14/2/2022. My lord has got it.
Page 32.
32.
You are which one? Your number, serial
After
number?
serial number 2, madam. 14/2/2022. Then,
21.
my lord, there was a writ petition at that point of time pending.
Bring my water for that.
Extension from 19/8/2021.
8/2021 to 14/2/2021. This was given on 21/9/2021.
Extension for 6 months.
6 months, madam. Because 130 came subsequent to this, madam. 9 June 2020. No, but 130 was there, madam. 138 they exercised and gave it. Now, my lord would come to page 33. That's a writ petition at that point of time pending before this honorable court. 4524/2021. Here, the order is of 29/9/2021. My lord, noticing that extension, page 36, third paragraph. Because this was placed in the court.
Yes.
As the respondents in the corporation department by notification dated so and so has already extended the term till so and so, it is observed that the petitioner society shall hold the AGM election such committee at the earliest within the extended period. Now, my lord would see at page 37 what we have done. We convened a meeting of the board on 17/12/2021. And fixed the, my lord, election or AGM
Yes.
on 31/31/2022. Then, my lord, we were directed by the department to take the permission of the deputy commissioner. We went to the deputy commissioner. Deputy commissioner's order at page 43, madam. The last line is enough, my lord. Last
DC
paragraph.
order dated
Dated, my lord, 3/1/2020.
rejected.
In view of the above, application for holding on so and so is hereby rejected. Then, my lord, we prayed for further extension at page 44. My lord would come to page 48.
Page 48.
Here,
yes.
48. Here, the, my lord, the journal, the local head that of the department, that's ARCS. My lord, he approaches the director saying that for these reasons they could not hold.
To the registrar, you mean?
To the registrar. He is a, my lord, assistant registrar of cooperative societies. He is writing to the registrar of cooperative societies. That we should be given an extension so that we can hold a meeting. Then, my lord,
But this page 48
lordship,
appears to be prior to your application.
no, this is after the rejection of my lord,
Just a minute. You see, page 44
lordship.
is your application for extension.
That my lord would find. This is before that, my lord.
Hmm.
This is before that.
One is, so ARCS has written a letter
Letter earlier, my lord.
for extension.
Extension, and we are also
Oh,
followed.
why? On what ground?
Because, my lord, will see this 4, my lord. That's how the board of directors will not be able to hold the election in due time due to COVID-19, and accordingly they took a resolution on 7/1/22 prayer for regarding exemption, which is clearly explanatory and for your kind necessary action. Because we have been taking resolutions to that effect. Now, my lord would come to page 49.
7/1/22.
This is page 44 is an application made by us directly to the register. Page 49. 10/2/22, we take a further resolution that the meeting for the year 21-22 will be, my lord, held on 22/3/2022. AGM, my lord, 22/3/2022, we propose. Because at that point of time, we are written for the extension had not come.
Yes, then,
My lord, will come to page 51, my lord.
yes.
Today's meeting discussed that during these days, we have been repeatedly requesting the so-and-so for holding so-and-so. Eventually, due to so-and-so issued by the government, the deputy commissioner has not granted us permission to hold annual general meeting election. In the meanwhile, the government had announced its decision to withdraw all COVID-19 protocols from 15 to 22 onwards, but the tenure of a managing committee will expire on 14 to 22. On the other side, short time, it's impossible to hold so-and-so. Resolve that nomination will be submitted on so-and-so and annual general meeting will be held on 22/3/2022. And accordingly, what he does, my lord, at page 52. Since your managing committee endorses this, my lord, it's an endorsement. Since your managing committee has not hold general election meeting, election in preceding year on due time, and cooperative department has not given direction. Until extension is given, the managing committee cannot hold any annual general meeting. We have been praying for extension. They have not been given. The second extension was due. Now, my lord, would
That was in February 2022.
yes, your
1
lordship.
year back.
I can't go and hold that AGM without the approval of the authority.
Then why have you come after 1 year? to
No,
this
I'm
court?
here before the court at that point of time only. It's not that I have come before my lord now. My
Then,
lord will see 16622/22, page 77. One 2022. This was on 9/3/2020. Immediately I was here. This honorable court said, till the next date, the respondent in the corporation department shall not take any coercive action against the petition. So, my lord, the default, if any, had occasion on that day itself. This was the order
and
passed.
here you paid for extension.
Extension, permission to hold the meeting. Madam. This matter is now pending before your lordship, and this interim order is continuing. And on the teeth of that, they have passed this order. Because it's not a case that I came before your lordship now asking for an extension. No, I'm there from that time, madam, because my second extension was due to me from 20.
But the problem now is that your 1 year period is also gone.
My lord, if that's the, my lord, prescription, my lord, the respondent is advancing, and my lord is pleased to record that. My lord will make it not only applicable to me, but to all societies. It cannot be a pick and choose manner.
Correct.
Any society which has been given an extension beyond the 6th year, my lord, should be closed. That board should be closed. Because the government cannot take two stands.
Only thing, my tentative view is that 6 years have elapsed. 130 does not appear to provide for an extension beyond 1 year. However, since there is a pending case,
My lord.
the disqualification cannot be applied to the case of the petition.
That board of directors disqualification, my lord, will otherwise also not come in because it's not my fault
Not
that I
your
could not hold the elections. But the thing is, my lord, the argument that is being advanced is not in connoissance with the arguments which were there in the other cases. Even before the division bench, my lord would see the division bench order para 14. My lord.
When are you hearing this matter before the who is taking up this 130?
My lord,
matter?
now nobody, but will have to come up before your lordship because my lord is holding the bench. So,
So-
lordship can have all those matters on 10th, I'll argue. My lord. Because that's the point, my lord. That's the only point.
That's the
My
only-
lord, it is also the stand of the government that beyond 1 year from the date, my lord, when they have ceased to become directors, my lord, no, my lord, exemption or extension can be granted.
My lord, he has not granted me the second extension, my lord. 1 year
That
thing
is
that
the
will not
stand
lie
of
in
the-
his mouth.
That is the stand of the government because
But the problem is,
Lordship.
in the meantime, the period has expired.
No,
That's
my
the
lord,
problem.
because if I may put it the other way, like we use it for the select list, my lord. If I come in between the select list, then my lord, it gets extended. Here,
Hmm.
I am before your lordship. During that validity period, my lord.
brought in.
During that validity.
In a-
period.
This is the
provisions of law.
constitutional mandate. is there.
My lord, if
Sir,
the
this
my lord
is-
sees
this
that
will not
division
apply,
bench
my lord.
judgment,
Huh?
constitutional mandate is 5 years, my lord.
That's what,
Then
That's
beyond
what-
5 years, they should
that's
not.
what, that's
They should
what,
not.
that is what,
Then how the 7th year they are giving, my lord?
that is what.
My lord, my lord
That
is.
is the very thing. That is Whether it can be done.
It can be
If-
done because of the exceptional circumstances that have come up. My lord, a normal cooperative society who has deliberately not.
Anyway, let us, I think we'll just issue notice that almost.
No, my lord, in the second case, I have not completed 6 years, my lord. For item number 43.
Just a minute, let us do this item 2 first.
But if my lord just issues a notice and the earlier order,
We'll decide the entire issue. All
When,
right,
ma'am?
that's okay.
because otherwise, my lord, this is going to be infructuous, my lord.
And naturally.
This
No,
petition will become infructuous.
But then
And-
it doesn't
and-
mean
and-
that,
And this dual stand, that should not be. permitted.
what dual stand?
Because, my lord, you in a particular case which was being heard, you don't raise all these objections. You allow it to be through. On the 7th year, you give the permission and you hold the election.
Show me that, that's what I've
That's
been
what I'm
asking you.
saying. That's what I'm coming. Come to page 66, madam. Come to page 66. My lord, we'll only come to page 66. My lord Justice Surana's order.
Yes,
Now, my lord would see the second paragraph at page 66.
yes,
Was elected in the annual meeting held on 5/7/2015.
5,
5/7/2015. my lord.
yes, yes,
The 5-year term will come into end on 4/7/2020.
correct,
This order was passed on 10/9/2020 within that
Correct.
6th year.
correct,
This is, my lord, Ambari Sadhuvasa Samabai Samiti Limited,
correct,
3502/2020. This Samabai Samiti, after this order, was restored and granted permission in its 7th year. That means in 20.
where is that?
My lord, that I have only brought this. I can bring that, bring on that order on record. My lord. Government order on record. Not only on that, even the second one, even the third one.
No, you show me that.
I can, I'll place that, my lord. My lord will only fix it day after tomorrow, but now it may not be possible.
Sadhu Basans.
Samavai Samiti Limited. Same thing, my lord. Page 66. If the department is taking a stand, let them take one stand, madam. And don't bring them that negative equality before your lordship, because this is deliberate.
No, you bring it on Monday.
Monday,
You bring it on Monday.
my lord. Sure, my lord. I'll do it. My lord will have this matters on Monday. I'll
There's a
place.
court's order.
Huh?
There is a court's order, Malay. If
What?
it is done, it has been done pursuant to the court.
How
Here is the
can you,
case,
how
the
can the
court has
court be
been resolved.
permitted to pass an
No,
illegal
so
order?
if the court can pass an order, it has been accepted by you.
Then why not in
Why
my
not
case?
in this case?
That's my case.
And your lordship.
But one thing is that, of course, that does not take away the fact.
Yeah.
That 130A will have to be decided.
It has to be, my lord.
And your lordship.
And this honorable court has been saying that it will decide it from the earlier round of litigation. Those whole set of cases, it has not been decided. He was supposed to place on record the entire gamut. I get that order is also there, madam. The last order in that litigation. My lord is not going for it. My lord will have it on 10th.
I need not go into all the facts of your case because you just give me the.
I'll give it on Monday, madam. On 10th, I'll place it, madam.
And if we decide one case, all the. other
All the cases will go. My lord will have it on 10th, madam. I'll come prepared, madam, on 10th.
Okay, right. Third, Mr. You can learn a senior counsel for the petitioners who submits that the order dated 18/3/2023 issued by the respondent number 3, whereby the board of directors has been dissolved and a one-man committee appointed should be set aside. He further submits that the respondent number 1 should be directed to grant a second exemption under section 130A, capital A, of the Assam Cooperative Societies Act, bracket amendment, bracket close 2021. Hereinafter referred to as the Amendment Act 2021. as the petitioners have not been allowed to hold an AGM by the respondent till the filing of the earlier writ petition,
162.
that is WPC 1622/2022. Next para. The petitioners counsel further submits that this court in its order dated 9/3/2022 passed in WPC 1622/2022 had passed an interim order that no coercive action should be taken against the petitioner. Full stop. However, the respondents have issued the impugned order dated 18/3/2023. Despite the interim order issued by the court in WPC 1622/2022, which is continuing till date. Full stop. The next para. No, next para. Mr. You can also submits that many other cooperative societies have been given extension under section 130A of the Amendment Act 2017.
No, 21,
No,
Amendment Act 21. It has been amended in 21.
2020. Is it 21?
Yes, yes. If your lordship sees, my lord, that
What did I say? Earlier 21? I said 21. Okay,
Yes.
21.
9 June 21.
21.
Mr. Yukinar also submits that many of the cooperative societies have been given extension under section 130A of the Amendment Act 2021.
Even in the seventh year. And as such, a similar extension should be given for the petitioners. Next para. Mr. R.K. Talukdar, S.K. Talukdar, the learned counsel for all the respondents
Cooperation Department. I don't know.
for the
that-
Corporation Department submits that no extension beyond a year can be given
Yes, beyond-
under section 130A of the Amendment Act, 2021,
From the date of, my lord, they cease to be directors.
in as much as the the term of the Board of Directors is for a term of 5 years. From the date
First.
When is that 5 years?
5 years, my lord, section 31. From the
From
date
the
of,
date of election of the directors. Good stuff. He also submits. Okay, from date of director, date of election as directors, as in terms of section 31 of the Assam Cooperative Societies Act, 2007, hereinafter referred to as the 2007 Act. He also submits that that the election of the board of directors has to be conducted before the expiry of the term of the board, comma, so as to ensure that the newly elected members of the board assume office immediately on the expiry of the office of the members of the outgoing board, comma, in terms of section 41 bracket 2 of the 2007 Act. Full stop. He also submits that section 31 of the 2000, section 31 and 41 bracket 2 of the 2007 Act correspond to Article 243 ZJ, capital, and 243 ZK respectively. Full stop. Next para, the learned counsel for the corporation department submits that on a reading of the 2007 Act and the constitutional provisions reflected above, the board of directors cannot hold office beyond a period of 5 years,
Subject to 130A, which is up to 1.
comma, subject to section 138A, 130A,
130.
130A of the Amendment Act 2021,
Which provides for 1 year.
which provides for extension of up to 1 year only.
So in this context, the government has issued a notification of the minutes dated 4/4/22. I'll place that one
Full stop.
in terms of this construction or
Full
interpretation.
stop. He also submits that the interpretation and construction of section 130A has been made by the government via an office memorandum,
Yes, well, a notification,
via a notification dated
4/4/22.
4/4/22. Full stop. Next para, the petitioner's counsel further submits that the order passed by this court on he also submits that the order dated 9/3/22 passed in WPC 1622/2022 only provides that no coercive action should be taken against the petitioner. Full stop. He submits that the said order cannot be interpreted in such a manner as to run contrary to the constitutional mandate provided in Article 247, 243 ZJ and 243 ZK. He submits that the said order would have to be interpreted in consonance with the Constitution and the 2007 Act, in which case the bar of disqualification from participating in the next election to the board of directors in terms of section 41(4).
No. In terms of 44.
In terms of section 40(4)(E) of the 2007 Act. Would be done away with. Correct, done away with.
No, in fact, the disqualification part will be considered by the court because the failure to hold the election cannot be attributed to them. My argument is twofold. continuation may not be permissible, but disqualification, that embargo, that may be lifted by the court.
He submits that, full stop, he submits that. While the continuation of the board of directors beyond 6 years would not be permissible, even if section 130A is applied. Full stop. However, the bar on disqualification can be decided by this court.
In fact, it has been decided by division bench. It can be lifted, well, division bench said, right table 31/19.
In terms of the, in terms of,
Well, read appeal 31/19,
in terms of the decision of the division bench in writ WA number
31/19,
31/19.
19. That has been
First
referred
up.
to, my lord, in this.
Next para, you're right. Section at page, where is that section 130A, Page-
132,
59,
59 or 6.
page 59, huh?
59.
Section 130A of the Amendment Act 2021 provides as follows. This is at here, page 59. From here to here. The issue whether whether section 130A can be applied after a board of directors has been holding office for 6 years is one of the issues that has to be decided in this case. Full stop. On the other hand, the petitioner's counsel shall also produce documents, notifications issued by the state government
Lordship,
giving extension
the 7th year.
to cooperative societies who have been, whose term beyond, who is continuing beyond 6 years.
Lordship. Extended beyond 6 years.
And whose terms have been extended beyond 6 years.
Fine.
Wide section 138. Wide application of section 138. List the matter on Monday.
Monday, 10th. And in the item number 43, my lord.
Similar.
No, my lord can have it together, there is no issue, but here the 6th year is running.
Huh?
6th year is running. It will end only in June.
Okay. So,
My lord, we can, if that's the contention, that therein, my lord, that order has to be interfered with and a direction to hold the meeting.
no,
is
let
only
them, yes, what to do?
43.
Both matter can be taken up together.
No,
If that can be disposed of.
you see, if their term has not expired, and if they have not been allowed to hold the AGM, why not have the AGM? Because there's no COVID. In fact, COVID is again coming. So better to have it fast.
At the earliest, my lord. And earlier we had approached this honorable court, there is an order not to invoke 39, no coercive action against us under 39 and 41 to
Yeah. Give me the other case.
43. 43, no?
Item,
10, sorry, ma'am, 10.
10.
My lord, I say that your lordship will definitely pass an order.
Huh?
Lordship will pass an order in the second case.
Huh.
Can it be on Monday? Your lordship will pass on Monday, my lord. Today is, my lord.
I don't know. Okay, right. On the prayer of Mr. S.K. Talukdar, then counsel for the cooperative department. This is the matter on
Both the
Monday.
matters together, my lord.
Monday.
Monday, fine.
Anyway, at least I've got some idea. about
Lordship.
it, Little bit.
Obliged.
Now we will open up the actual facts. Because
That is what is very scary.
I'm also.
I'll come back to you.
You are going to bring a lot of,
I'll not bring
Reading
anything. I
material.
will give before my lord the
Ah.
dual stance taken. And they will have to answer why they have taken. Because
But one
if this
thing-
is the law,
Hmm.
they'll have to take that law everywhere.
one thing you have to keep in mind, the
Lordship.
fact that you see, we have to take a decision on 138.
Lordship.
Now, just because they might take they might have taken decisions contrary to what this court might decide.
I'm not on
Would
that.
not, huh?
I'm not on that.
Okay.
I am only on the fact that if this is the, as my friend has put before your lordship, if that is the understanding of the department,
Department.
in the other cases, they should not have made any other submission. No. my
It's
lord,
a
no,
learning process.
No, it's not a learning process because this is, they say it's there from 22. They have solidified it in 22, my lord. So 22 onwards, after that date, they can't have a contrary argument. I'll place that before your lordship. And this was never highlighted before this honorable court. This is the first case that they have highlighted.
Maybe because I had expressed my mind a little bit.
Not
Oh,
like that, but every court has been expressing, I'll show it from the records. This factor, for at least, my lord is the third court
okay.
to express this opinion. That
Okay.
whether it's 1 year or there are two parts to that. This is a confusion. This is what the honorable court
Lordship will
said.
decide on Monday. Then it will, my lord, this issue will be set at rest on Monday.
My lord,
Lordship
in
will decide.
item number 10, in page 4, my lord, there is a correction. in
How
the
you
name.
make correction?
Much okay.
As long as the correction is not on the cost
No,
title.
if the name, my lord, got copy pasted, the name was
Okay.
wrong. my lord. It's
Not on the
okay.
cost title, because cost title, what happens is then the
No,
ISCIS.
not on the names, my lord. It's in the cost title itself, but in the, my lord,
Okay,
top
no
portion.
problem, no problem. with that.
Illegal issuance, that part, my lord.
Okay, next.
Much okay. Non-payment of contractual bill.
No. Yes, what to do, madam? Notice. Okay, heard, Mr. And Ahmed Learned Counsel for the petitioner who submits that the petitioner has not been paid his contractual dues amounting to rupees 5,53,63. Issue notice returnable in 4 weeks. Ms. J. Gogoi accepts notice on behalf of respondents number
1 to 4.
1 to 4. Mr. A. Hassan accepts notice on behalf of respondent number 7. While Mr.
TJ Das 4, 5 and 6.
A.J. Das.
TJ Das.
TJ Das.
D,
C-
D for Delhi.
D.
D for Delhi.
D for Delhi.
Yes.
J for Japan.
J for Japan.
Accept notice, CGC.
CSC. Lord.
CGC accept notice on behalf of respondents number 5 and 6. List the matter out of 4 weeks to enable the respondents to obtain instructions and file affidavit if necessary.
Obliged.
Extra copies of the writ petition be provided to the council for the respondents within the course of the day,
Within 3 days, my lord.
within 2 days.
May I please, your lordship? The petitioner before your lordship is AAY card holder, your lordship, Antodaya Anna Yojana, your lordship. It's a ration card, your lordship.
Okay,
Under the National Food Security.
show me where the proof that you are a AAY
Yes, your
holder.
lordship. Kindly, page number 10, your lordship.
Page number 10, yes.
Page number 11A is the vernacular, your lordship.
Page number 11A.
Okay, yes. Annexer,
Okay, okay.
Dilbhanu, your lordship.
Yes, there.
Now, your lordship, under the National Food Security Act, your lordship, section 3 provides that,
No, so what is your problem?
your lordship, I am entitled to get 35 kilogram of.
You are getting only 10 kg.
Yes, your lordship.
You are getting what? You're getting rice which is for a BPL. Is it? BPL gets more or AAY gets more?
AAY is small, your lordship.
AAY is more. So BPL below poverty line, they are on a highest level, is it? They are more well off than AAY, is it?
The act is more specified, your lordship.
Show me.
My lord, kindly peruse section 3, your lordship. Page number 5,
Section 3.
second page, your lordship, bottom.
Yes.
Right to receive food grain at subsidized price by person belonging to eligible household under targeted public distribution system. Now, my lord, the relevant portion is next page, your lordship.
Yes.
Kindly. Provided that the household covered under Antodaya Anna Yojana shall to such extent as may be specified by the central government for each state in the said scheme be entitled to 35 kilograms of food grains per household, my lord. And I was get 35 kilogram initially, my lord, up to October 2019. Then after that, my lord, I am
After
getting
that, they are getting 10 kilograms.
10 kilogram, my lord,
And 10 kilograms is usually given to whom?
to a family, your whole.
Okay, so this is your case.
Yes, your lord. We have approached the respondent several times, my lord, but
So what do we do? Who is it? Have you filed any representation?
yes, your lordship.
Well,
And Annexer B. Annexer B, page number 14, your lordship, is the
Okay.
typed copy, and vernacular is page number 15. Before the secretary.
So should we tell the secretary to dispose of your representation or what?
Yes, your lordship is the competent authority, my lord.
Is it public? है ना?
Yes, my
As-
lord.
35 kgs of rice he's supposed to get,
Yes, madam. I take instruction, madam.
right?
Because madam, the card may have changed, madam, in the meantime.
Ah.
Petitioner is the old lady, my lord, and widow lady, depending.
Has your card been changed?
No, your lordship, till
No.
date he is on to the.
So that, you see, we'll say that it should be disposed of by a speaking order. So let that person dispose it of. By the time you take out instructions, 6 months will elapse. They want 35 kgs, not 10 kgs.
Yes, madam.
Every month losing 15 kgs for a poor woman is quite a big thing.
From October 2019, my lord.
Then why did you come so late?
We
From
have,
2019 and your letter is of November 21. 19, 20, 21.
COVID pandemic is there, your
COVID
lordship, and old lady, my lord, she
Okay.
cannot approach.
Okay, right. Right, Mr.
Ardash, your lord.
R. Das, learned counsel for the petitioner, who submits that the petitioner is a Antodhaya,
Antodaya.
Antodhaya Anna Yojana bracket AAY, bracket close, card holder, which was issued in the year 2014 under number 44 Paschim Pakka Gaon Panchayat of Desh Bhakta Samabhay Samiti Limited. Pustak. The AAY card bears number 0579386, registered serial number 129, ward number 5, house number 120, Barpeta district. Pustak. The petitioner's counsel submits that the petitioner being a AAY card holder, she is entitled to receive 35 kg of food grains every month in terms of the proviso to section 3
Yes, your lord.
of the National Food Security Act 2030. Pustak. While the petitioner, who is 53 years
Yes,
old,
your lord.
53 is not old.
But widow lady, your lordship, and
Widow
having,
doesn't mean old.
and having one unsound son, your lordship, in the house.
What have I said?
While the petitioner,
Well, the petitioner, who is a 53-year-old widow, was receiving food grains, 35 kgs of food grains per month till October 2019, the same has been reduced to 10 kgs per month without any reasons being provided to the petitioner. Yes, sir. Though the petitioner had submitted a representation dated 19/11/2021 to the secretary, Desh Bhakta Samavai Samiti Limited,
Another one before inspector, your lordship. Next page,
and
page number 16.
representation dated 20/05/22 to the Inspector Food, Civil Supplies and Consumer Affairs Department, Barpita, to allow her to draw 35 kgs of food grain per month and compensate her for the short supply of food grains for the last 2 years, no action has been taken by the respondent numbers 2 and 3 till date. Full stop. Next para, the petitions council thus submits that a direction should be issued to the respondents number 2 and 3 to take a decision on the petitioner's representations within a specified time period. Full stop. Mr. Mr. M. Chetia, learned counsel for
1 and 2 months.
1 and 2. Submits that. He has got no objection to the prayer made by the petitions council. Full stop. Next paragraph. In view of the fact that the petitioner has been, in view of the fact that the petitioner's grievance is with regard to the short supply of food grains being given to her since November 2019.
October.
Oh.
Oh, okay, your lordship.
November 2019. And due to the fact that her representations have not been considered by the respondents number 2 and 3, this court is of the view that the respondents number 2 and 3 should take a decision on the petitioner's representations by way of a speaking order and ensure that the petitioner is given food grains as per her due entitlement. Accordingly, the petitioner number 2 is directed to take a decision on the petitioner's representation dated 20/05/2022, bracket annexure C, within a period of 1 month from the date of receipt of a copy of this order, accompanied by a copy of the writ petition. Full stop. Similarly, the respondent number 3 is directed to take a decision on the petitioner's representation dated 19/11/2021 by way of a speaking order. Petition representation dated 19/11/2021, bracket annexure B, by way of a speaking order within a period of 1 month from today, and communicate. No, full stop. The respondent number 2 and 3 shall thereafter communicate the decision taken by them to the petitioner. The petition is accordingly disposed of.
I love like my lord.
1 minute.
Okay, বুঝছেন না? মানুষ তো বইছে। হ্যাঁ, এটা বলবে। এরপর খালি বলতে যে হ্যাঁ, আমি যদি বুঝিয়েছি এর ইচ্ছে কেটে মানে কেন একটা বুঝিয়েছি 8টা বাজার দিয়ে বইয়ে ওই দিন পড়াশোনা কথা হলো স্টাফ যদি ইয়াতে ঘুমাবো তাই দুজনে ঘুমাবো ব্যাপার আছে শিক্ষক শিক্ষক কিন্তু কম লাগতো ট্রান্সফার করা যাবে regarding my lord, the tender process, my lord, whereby my lord, on a tender dated my lord 3/8/2015, my lord.
Huh?
By a tender dated 3/8/15, the
In
petitioner,
NIT dated
and I dated 3/8/15, my lord.
3815, huh?
The petitioner was initially given the contract of managing the solid waste management of the Tezpur town for a period of my lord 20 years by an agreement dated 15/12/2015.
Just a minute, for 20 years by
An
agreement dated
my lord 15/12/2015.
15/12/2015.
15/12/2015.
Then what happened?
Then, my lord, after execution of this agreement, my lord, he started his work, my lord. And later on, my lord, the 1/2016, my lord, 25/1/2017, my lord.
Huh?
On 25/1/2017, my lord, later on,
25/1/17,
my
yeah.
lord, this principal agreement has been modified.
Agreement modified, the earlier, so new agreement made.
New modified agreement has been made and two conditions have been brought in. The first condition is that, my lord, the 20 years lease period has come down to 5 years.
This contract,
Contract agreement which has been made for 20 years, that has come down to 5 years. And, my lord, and another condition remains there that, my lord, after completion of these 5 years, my lord, he may be, my lord, this agreement may be renewed.
may be removed.
May be renewed, my lord. And accordingly, my lord, he has completed his tenure, my lord. He has completed this 5 years tenure.
And on 22 January,
22, my lord, on my lord, the 1st May 21, my lord.
let us see the 25/1/17 agreement. Right,
That is, my lord, at page 31. This deed of agreement is made on the day of 25 day of.
so
January.
it'll take effect from 1/6/2016
1/6/2016, my
to 1/5/2021.
21.
So
During this period, my
just a
lord,
minute. When was this agreement made?
it was made on, my lord, 25th June 2017, my lord.
Then you were saying 25/1/17, you're giving wrong date.
No, no, this agreement has been executed on 25th January 2017. Page 31, my lord. But the effect was given from 1st June 2016 to 1 May 2021.
Where's the date?
But in the initial, this deed of agreement is made on this, the day
25,
of 25th day of January 2017.
25,
One,
25th June.
not June, it is January.
January.
January, this sub-register seal, there is, the date is written 25/1/17.
But then you come to page 35. Come to page 35. Come to the, in the bold, in witness whereof.
And then seal on the 1st June 2016 at Tezpur, Sunitpur, Assam. Well, there, the seal and signature of the sub-register in the page 31,
Okay, it was registered on so and so. It was
Registered
registered on 25.
55/1,
Okay.
and it was signed on that day,
It was registered on 25/170. Okay.
25/1/17,
Ah.
And
Agreement was made on 1/6/16. And registered on 17. Ah. So out here, the period is from 1/6/2016
to 1
to
May
1/5/21.
21.
Then, so 5 years have gone, then,
5 years has gone,
then
Then,
where is the extension?
and then an extension was given, at page 53,
Yes,
With reference to your letter number so and so dated 14/6/21. For extension of lease period, it has been decided to extend the lease period for 1 year with added terms and conditions. Annexure 1 as per an agreement number so and so dated 25/1/2017. And the resolution number 3 of 3/11/15 with effect from 1st May 21 to 1 May 2022. However, formal agreement which shall be made after normalization of COVID-19 pandemic situation only.
26/7 for extension.
Or extension, the extension has been given.
For extension from 1/5/21
To 1
to-
May 22,
1/5/22.
Lordship.
Now, yes, then after that, any other extension?
No other extension.
So you are working till date or what?
I am working,
You're working.
working, tell me, there are two parts in that, in this agreement actually. One part is collection of the solid waste from door to door. Another part is the management of the plant, solid waste plant. In doing that, in management of this, so far the collection of the solid waste from door to door, it is still going on. And the plant is closed right now because of maintenance and other works. Although they have not given any formal letter to me to run the plant or not to run the plant, but they are verbally saying that you go on running the plant. Because the waste used to deposit there, that has to be disposed.
Ah.
And these things are there, and no, they have not called for any further tenders also. And this requires some expertise also, my lord. These things are there. And so far, my lord, this collection of waste from door to door, now they are adopting choose and pick policy. They are engaging several parties, my lord, to collect it from door to door, from ward to ward. And in such a letter, my lord, the last letter, my lord, I am coming, my lord. That is the page, my lord. Page 59, my lord.
Yes,
This letter has been given by the president and secretary to the president and secretary by the, my lord, chairman, Tezpur Municipal Board, Tezpur. Whereby, my lord, this for collection of the, my lord, solid waste from door to door, they have given some orders, my lord. In the page 60, my lord, my name is also there for collection. That is one, I have given certain wards, my lord, 1 to 11, 18, and 19. I am at number 1, my lord. And some other parties are also given, my lord, for collection of this waste. Now, my lord, my answer is that, my lord, they are using, my lord, adopting the pick and choose policy. And of late, my lord, they have given one notice to return my vehicles to them. The vehicles which I am using for collecting the, my lord,
That,
solid
those are not your vehicles.
no, vehicles are, some vehicles are mine. Some vehicles are from the municipality board.
So the municipal vehicles, they wanted returned.
The vehicles which I am using for collecting the waste. They want back those vehicles.
So what is wrong?
My lord, whereas my lord, by this order, my lord, they have allowing me to collect from door to door.
You say that you don't want to collect, they're not forcing you to do it.
No, no, my lord. No, I am collecting, my lord. I
You
am
want to
collecting.
collect.
I want to collect, my lord. So on the other hand, on the one hand, they are allowing me to collect, on the other hand, they are asking me to deposit the, my lord, the vehicles, my lord.
You see, so what legal right of yours has been violated?
My lord, my lord, either they have to call some for my lord and for tender, my lord, for this, because plant has to run, my lord. And neither they are calling for any tender, nor they are, my lord, they are adopting this fees and queues policy, and they are just collecting these doors.
So what do you want? What is your prayer?
My lord,
regarding
my
the-
prayer, my lord, I have submitted a representation also, my lord. On my lord. Hmm? On my lord, 27/4/22.
You see,
That is also pending.
do
my
you
lord.
have any enforceable right? Look at your prayer. Your prayer is
Lord,
that
they
your
have-
contract agreement should be renewed. Is it an enforceable right? And
Either, my lord. My
what
lord,
do you want? What do you want right now? You want a representation to be decided or what?
my
Because
lord, let the representation be disposed of, my lord, that I have given on 27/4/22, my lord. Then, my lord, that.
he doesn't want to lose his this solid waste management work.
My lord, actually, my lord, I have taken loan also to run the plant, my lord. Loan of rupees 17 lakhs. I have invested more than 70 lakhs in running the plant, my lord. My lord, after completing it, my lord, it took several years to do that, my lord. And after.
Why
completing-
did you agree to that modification of the earlier agreement?
That is the mistake, my lord, that I have done, my lord.
Then
That is the mistake, my lord. After completing everything, my lord, well, I have done a hard labor. My lord, I have trained up people from my at my own post at IIT Guwahati for running those plants, my lord. after that, my lord,
it was your
when-
fault.
When my lord, the plant has come to a position of my lord, giving production, my lord, then my lord, they have now coming to this, my lord.
But what to do?
My lord, my just representation may at least be this, my lord.
Right, heard, Mr.
Uses, yeah.
UJ Saikya Learned Counsel for the petitioner who submits that in pursuant to a notice inviting tender bracket NIT dated 3/8/2015 for solid waste management in Tezpur town,
Lord.
the petitioner submitted his bid. The petitioner being found to be the successful tenderer, comma, an agreement dated 3/8/2015 was executed between the petitioner and the respondent numbers,
Number 4,
respondent number 3,
3, Lord.
for collecting waste from various houses in Tezpur and managing the waste management plant. Is it? Waste management.
Solid waste minute.
Huh?
Solid waste.
Solid waste management plant. Full stop. Anything? Yes, some.
No.
Full stop. The petitioner's counsel submits that a modification to the agreement dated 3/8/2015 was made by way of an agreement dated 25/1, no, but by way of an agreement executed on 1/6/2016, comma, which was registered on 25/1/2017 between the same parties. Full stop. As per the new agreement, comma, the lease period for door-to-door collection of garbage and running of the solid waste management plant was reduced from 20 years to 5 years with effect from 1/6/2016 to 1/5/2021. In the latter agreement, another clause was inserted wherein the agreement could be renewed between the parties. Next paragraph, the petitioners council submits that on expiry of the 5-year period, the contract agreement between the parties was renewed for a further period of 1 year. From 1/5/2021 to 1/5/2022. He submits that subsequent to 1/5/2022, the petitioner has been allowed to continue with the door-to-door collection of household / shops / commercial establishment, door-to-door collection of garbage from households / shops / commercial establishment. Full stop. Though the petitioner is still is to run the solid waste management, the same has been closed for repairs and maintenance. For repairs,
For repairing.
for repairs. Full stop. Next paragraph. The petitioner's grievance is that the respondents have distributed the door-to-door collection of garbage within Tezpur town between many firms and individuals, which also includes the petitioner. He submits that a few wards in Tezpur town have been allocated to the petitioner for collection of garbage. The petitioner's council submits that in the normal scheme of things, a fresh NIT should have been issued. Is it?
Yes,
A fresh NIT should have been issued by the respondent to select the successful tender for collection of garbage and running the solid waste management plant. The petitioner being aggrieved by the present arrangement being undertaken by the respondent number 3 in distributing the collection of garbage to different firms and individuals, the petitioner had written a representation dated
The 27/4/22.
27/4/22 to the respondent number
Oh, 3.
3. He submits that the said representation has not been disposed of till date. He further submits that this writ petition can be disposed of if a direction is issued to the respondent number 3 to dispose of to take a decision on the petitioner's representation dated so and communicate the decision made to the petitioner. Mr. M. Chetia, the learned counsel for
I am for my lord, 1, 2, and 5, my lord.
response number 1, 2, and 5. What about 3 and 4? No, who's
There is the my lord, municipal board, my lord.
1, 3, and 5?
So, my lord, in depth.
Mr. Submits that he has got no objection to the prayer made by the petitioner's counsel.
Yes, my lord, already, because my lord, contract has already been expired, my lord. That is why, my lord,
First off, he however submits that as the contract period between the petitioner and the respondents number 3 and 4 has already expired, nothing remains in this writ petition. Full stop. Next paragraph. On considering the fact that on hearing the counsel for the parties, it is clear that the contract period between the petitioner and the respondent number 3 and 4. No, it is clear that the contract period of the petition has expired. First of, however, the petitioner has been allowed to collect garbage in terms of the letter dated 7/12/2022 issued by the respondent number 3. First of, as such, this court is of the view that the petitioner's representation dated so should be examined and decided by the respondent number 3. Accordingly, the respondent number 3 directed to examine the petitioner's representation dated so and take a decision on the same, within a period of 1 month from the date of receipt of a copy of this order. And the decision taken by the respondent number 3 should be communicated to the petitioner.
Till then, my lord, the status quo shall be maintained, my lord.
What status quo?
My lord, that I am collecting, my lord, they will take my vehicles, my lord, I will not be able to collect, my lord. Till then, I will keep disposal, my lord.
Where is the status? Where is the order saying that you should return the vehicle?
My lord, it's there.
105, my lord.
Huh?
It is my lord, at 27 to 23, my lord.
Page?
Page, my lord, 105.
But this is not your vehicle, Mr. Counsel.
My lord, these will be required for collecting the, my lord, and that's why, my lord, I am saying, my lord, the status quo shall be maintained, my lord, till then, my lord. Only till the disposal of the, my lord, representation.
Under random vehicle, my lord. Third party right have already been, may have been, my lord, created, my lord. I cannot say, my lord.
This period has also expired. You have
Yes,
not come before the period. Period expired long time back. The writ petitions accordingly disposed of.
What?
Please, your lordship. My lord, here, my lord, this petition, my lord. This is the extension of the term of settlement of fishery, my lord.
When, so it expired,
My
your term of,
my lord, I mentioned this matter on 27th, my lord, but it was not listed. It has been listed. And till now, my lord, no NIT has been issued, my lord, and a representation is also pending. So they may give extension with effect from first of.
have they've not issued any NIT.
No, my lord.
So. No, that they will decide. Who are we to
Yes, my
say?
lord. That is why, my lord, the representation is.
You take a
pending.
decision
They
on the
may decide.
representation.
I have to take it. I think NIT is being issued. Yes, but I think so.
No, whether
No,
NIT is issued or not.
That will be, I can confirm within 2 minutes, Lordship.
Okay, confirm.
Your lordship can fix up a date, otherwise, my lord.
No, 2 minutes. He's taking only 2 minutes.
Yes, my lord.
Yes,
My lord. This, some youths, established a brick industry. And they have obtained, no objection from the various authorities. My lord. Then they also, install some instruments like chimney and develop the land to get ready. Then some persons and some nearby brick owner lost some complaints from some persons to the deputy commissioner. Then deputy commissioner directed the circle officer to conduct an inquiry. Then circle officer conducted an inquiry for the allotment, who is also against us. My lord.
everyone is against you.
And the factory located within 3 kilometers, there is no brick industry, there is no school, there is no residence. It is a fact, my lord. Then, my lord, one inquiry has been conducted. Then
What has been conducted? Inquiry.
inquiry, but for a large one, he reported that without taking permission, I am operating the industry, but it is not a fact. Last I, after taking no objection certificate from the various authorities, we developed the land and installed some instruments. Then thereafter, Deputy Lordship kindly see a public meeting was held where the pollution control board officer was present. He conveyed all things to the people. People is giving no objection, my lord. Lastly, my lord, the deputy commissioner passed an order. The Lordship kindly see page 72. Pollution control board, after conducting, giving me certificate, my lord. Before that, my lord, if you also kindly see page 68, my lord. Page 68, before that. Annexure element, page 68. Last is the pollution control board has also issued this letter, consent to stabilize. It is given on 12th April. Then thereafter, my lord, consent to operate, page 70. We submitted all those documents to the deputy commissioner. Thereafter, deputy commissioner issued this letter, page 72.
Yes, so
Then accordingly, a public meeting was held on 1/12/2022.
when?
1/12/2022.
1/12/22.
1/12. You will also see paragraph 20, page 11 of my petition, my lord.
Yes.
There is a, accordingly, hearing was taken place on Sensu, and some persons appeared in the said meeting who are outside of the area of operation. In the said meeting, one person of Borua alleged that before establishing a Sensu industry, no information was conveyed to the surrounded spectators. And one popular Raskwa, Sensu alleged that said Itabeta will establish, then the cultivable land will be damaged and there will be pollution, and 2 or 3 persons objected for replacement in the industry, but those persons have no land within the area of operations. But large number of people supported for establishment of the Swensu brick industry, and they also stated that if the Swensu industry will operate, then there will be no harm to the people, and even the local youth will get employment and will be benefited. The petitioner further stated that when the people attended in the said public meeting hearing, were asked to put their signature, but they did not put their signature, my lord. So, cycle officer, I got information, cycle officer send this proceeding of this meeting to the deputy commissioner.
So,
But till that, no action has been taken, my lord. No action has been taken.
so
So, till I,
you want the deputy commissioner
to take a decision.
to take a decision.
Decisions, my lord. Because my lord, kindly see, all the formalities I have been completed, my lord. We take objection from the forest department, agricultural officer.
Yes.
Pollution control board also give the certificate. my lord.
This is the issue notice, lordship. We will come up with a detailed instruction, lordship. And otherwise also petitioner have to include the pollution control board.
Huh?
Petitioner have to include the pollution control board as a party here, lordship. And he is not included in.
No, he doesn't want because he says that the certificate is there.
Given, my lord,
Certificate,
element
lordship, one certificate was expired on 30, kindly page 70, lordship.
No, that may be.
Page 70, lordship,
there-
the CTO is valid up to the period of 31 to 20.
That is
Already
factory
lapsed,
certificate,
lordship.
level certificate. We cannot operate.
No,
Because of 1 year, they are keeping my.
lordship consent.
No, that is, you see, those things will, you see, that is
Well,
a
the black
continuous
police
process. And the period expires, then they will apply again. Every year
apply
they'll apply. That is a
Also-
different issue. I want to know the decision of the public hearing.
So, lordship may issue notice in this short notice, lordship. We will come up with a decision which was taken in the public hearing, lordship. We will place it, lordship.
Or should we direct the DC to
Yes.
give his decision and give it a
Yes.
copy to him?
Yes.
Why should we wait for this? Everything gets delayed.
I have.
Let a DC take his decision on the basis of the public hearing and communicate the decision to him.
Lordship, I have no problem.
That will, I think,
Lordship,
solve
Lordship.
everyone's problem.
Lordship.
Otherwise, you'll have to write a letter and
Lordship.
heard, mister?
Yeah.
J. Ahmed, learned counsel for the petitioner, who submits that
Only
the
because some public-
petitioners had established a brick industry, a brick kiln,
Brick kiln industry.
brick kiln, KILN, huh, brick kiln, in the name and style of MS N+R brick industry in village Raigondia,
Right,
Ba-
yeah.
Bagari Guri Pathar, under Jajori police station in Nagaon district. They also obtained no objection certificates from various authorities to establish the brick tin. Full stop. The petitioner's counsel submits that there is no inhabitant within 3 kilometers
2.5 or
of the brick kiln, and neither is there any religious place of worship. Don't say religious worship. Yeah. You see, even my English is going from bad to worse also. Religious place of worship, schools and other public institutions within an area of 2.5 km/3 km from the brick kiln. Full stop. The petition, next paragraph, the petitioner's counsel submits that due to some complaints made by some persons, comma, the the office of the Deputy Commissioner Nagaon, via letter number NRP full stop 18/2015/395 dated 16/11/2022. Directed the circle officer, comma, Nagaon Sadar Revenue Circle to conduct a public hearing with regard to the N+R brick kiln at Bagari Guri under Hattichung Mauza, Rai Dongdia. Page 72, huh? Full stop. The petitioners, next paragraph, the petitioners counsel submits that the petitioner has not been informed with regard to the decision taken by the office of the Deputy Commissioner Nagaon in respect to the public hearing that had taken place
one.
on 1/12/2022, comma, in pursuance to the letter dated 16/11/2022 issued by the office of the Deputy Commissioner Nagaon. He submits that this writ petition can be disposed of if a direction is issued to the office of the Deputy Commissioner Nagaon to take a decision on the setting up of the N+R brick kiln by the petitioners and communicate the said decision to the petitioners
Within a period of
within a specified time period,
1 month.
within a period of 1 month. Mr. K. Gogoi, learned counsel appearing for the respondent numbers
All the best.
2 and 3, Lordship.
2 and 3, and Ms. G. Hazarika for respondent number 1, submit that they do not have any objection to the prayer made by the petitions counsel. Next paragraph. In view of the consent of the parties, comma, the office of the Deputy Commissioner Nagaon, bracket revenue branch. Earlier also you put revenue branch, this shall take a decision with respect to the public hearing held on 1/12/22 by the circle officer, Naugong Sadar Revenue Circle in respect of the N+R brick kiln and at Bagari Guri and Hatichung Mauza Raidongya
Please.
and communicate the said decision to the petitioners within a period of 1 month from the date of receipt of a certified copy of this order.
Lordship, Lord.
And the writ petition is accordingly disposed of.
I may also submit a copy of the writ petition.
The petitioner is at liberty to serve a copy of the writ petition along with the certified copy of this order to the Office of the Deputy Commissioner Revenue Branch
Since I have been not heard, my lord.
for compliance of this order.
Since I have been not heard.
Full stop. Further, prior to taking a decision, the Deputy Commissioner the Office of the Deputy Commissioner, Naugam bracket Revenue Branch, shall give an opportunity of hearing to the petitioner prior to taking a decision on the matter.
Hello, Lord.
Lordship, if Deputy Commissioner had taken the decision on the basis of the public hearing,
Full
Lordship.
stop. However,
Lordship,
if a decision has already been taken
Lordship,
as on today,
Lordship.
comma, the said, the decision, it shall be deemed to be substantial compliance
Lordship,
with the order if the decision is communicated to the petitioner without hearing the petition.
Lordship,
I have not communicated any such decision until that, my lord.
But it might be in their file.
That's fine.
You see, one thing, you see why, then you can come again, that is, but one thing is that if you have been given prior opportunity of hearing, then that violation of principles of natural justice, that
Public
would.
hearing, Lordship, public hearing, when public hearing is conducted, Lordship, the petitioner is also present because Lordship.
No, we are
on
not
the-
informed, we are not
On
present,
the
my lord.
basis of that, Lordship.
Distance filings having taken
On
place.
the basis of
5
the
kilometers away.
public hearing.
Anyway, we'll see. I will just clarify the order.
Lordship, Lordship.
If he has not been heard, that's all.
Otherwise, in the after.
Be giving the opportunity of hearing, we said, no? If he has not been heard in the public hearing.
Yes, my lord.
Lordship, Lordship, Lordship. Obligable.
With your lordship's leave, there is an item 14 where the learned advocate general is. He has some personal difficulty. May it please, your lordship. The point involved in this case is that in the garb of regulating the handloom industry, order has been passed by the government, basically, which is a blanket order. My case is that it's a prohibitive order. It's not a regulatory order. Well, your lordship will first come. Well, I'm a trader engaged in the business of trading different varieties of textile cloths. And your lordship will come to page 53. Well, what has happened? The central government has passed a law in the year 1985 where the handloom parts throughout the country are being protected. And it is known as the Reservation of Articles of Production Act 1985.
What? Page 53, yes, I'm in page.
This is the impugn order. First, I'll.
Page
come to the-
53 is the impugn order,
Yes, lordship. 54, lordship.
54.
Before, well, this is the impugn order by which our business of
Which page?
page 54 of my writ petition. First, I'll read the impugn order,
Yes.
then I'll go to the rules.
This is
by the-
notice, this is a notice.
Yes, Manoj. This is by the director, Assistant Director Handloom. This is to inform that the vendors of all textile establishments and commodities in Kamrup district that according to the Handloom Reservation of Articles of Production Act 1985, in Assam, the sale of gamuchas, mekhala chadars, dakhanas, which are produced in powerlooms of other states, is strictly prohibited with immediate effect. Therefore, you are requested not to sell such textile within the territory of Assam. Otherwise, appropriate action will be taken according to the law. In addition, I would like to inform you that you are requested to encourage the indigenous weavers and benefits them financially by arranging the sale of woven gamuchas, mekhla chadar, darkhanas manufactured by the indigenous weavers of in Assam. Now, before I start my submission, I like to make it very clear that I know my limitations. Under the Act, the handloom industry has to be protected, especially indigenous. But I will show that in the garb of protecting the handloom industry, my production, which does not come within the rules, have also been prohibited. That is my case. So because I know my limitation, because the
No,
Supreme
no,
Court,
you are producing
I
how?
am producing,
By
what
way
I
of
did, I take products from outside the state and I make
Not handloom products.
No, not handloom products. In fact, these are powerloom products which I make, and I don't take the legal parameters. The legal parameters is that there are certain criterias which I cannot make because that has to be protected for the indigenous handloom. There I cannot have any reservation because the law is settled by Supreme Court judgment. What I'll show from the documents that your lordship will come to page 13 of my writ petition. That will make it clear.
Page 13.
Yes. Paragraph 9, if I may read, lordship.
Yes.
Page
Page 14.
Page 14, para 9. That the petitioner states that the product which they are purchasing is made and manufactured by powerlooms or selling under them to their vendors are of different composition and not within the ambit of range of articles whose specification has been mentioned in any range of products which are manufactured specified in Handloom Reservation of Article of Production Act 1985. The said fact is also fortified by the petitioner as the product code under which the goods are being produced and sold is under HN code number 5407 and 521, which makes the product, this is important, distinct and different from any range of products mentioned in the Act of 85 and therefore are exempted from the said Act. The product under HMN code of GST has been mentioned are basically a blend of man-made fibers. HMN code 5407 stands for woven fabrics of synthetic filament yarn, including monofilaments of 67 decitrix and with a cross-sectional dimension of 1 millimeter. HS code 520 stands for woven fabric of cotton containing predominantly but 85% cotton by weight, mixed principally or solely with man-made fibers and weighting such. Well, here,
Now you are selling this 5407.
yes, yeah, I've been all along selling, but because of this, I will now take your lordship to the invoices, your tax invoices at page starting 37, lordship. The lordship will find at page 37. Page 38 will be relevant. The code is there down below, name of the product. The second one is the HM code.
Where? Mr. Kamal?
Malat, in the column 1 at page 38, down below,
Yes, down below.
name of products.
Name of product.
If your lordship
Name
comes,
of products in the middle.
yes,
you
if
will-
your lordship comes to the first column, HMN code,
Yes,
HSN code 5407,
yes.
which is specified in paragraph 9. The next page, your lordship will find same HSN code at tax invoice page 39, HSN code 5407. Then at page 40 in the tax invoice, again, HNN code is specified 5407. So I want to show that I don't come within the purview of the table in the statute. Now I'll take your lordship to the table. Annexure, page 53. Well, it starts from page 44, the act, because the power has been delegated to the state government also, they can take action. And your lordship will
Page?
come to page 53. 11, at table 11.
Yes.
This is the product. Malad, this is the bar which we can't do. Chadar, Mekhala or Fanik at serial number 11. Lordship has got it?
Yes.
Can I read? Chadar, Mekhala or Fanik is used for covering lower or upper part of the body and is manufactured from, this is important, Lordship, cotton yarn or silk yarn or art yarn, art silk yarn, or in any combination thereof, woven in plain or twill weave, with check or stripe design, irrespective of counts and dimensions, and is characterized by a border and or cross border with extra wrap and or extra weft design, and includes the other states. Mizoram, we call it Pon, Dhara, Meghalaya. So these are the indigenous products where is a specific bar, and the legal specification is also there. So we never trade on that because our H&N code clearly shows that we with viscose or with polyester and cotton mixture, we do it. So there could not have been a ban. Now what has happened? The government of Assam.
No. So how do you say that 5407 and 5210 are not covered by this?
Because the contents, what has happened, if your lordship sees the table, Chadar Mekhela Panek, the specification is is clearly stated that it can be cotton yarn or silk yarn or combination of both, nothing else. If the principal rules of interpretation, if the statute has to say something, it has to be very specific, explicit. I have a judgment of the Supreme. So they never mentioned about polyester. They could have included, because then I don't come. Because my trade in other products is on a different area.
But yours is also mixed with cotton.
No, it is not. It is mixed. 540 doesn't talk about cotton. Lordship will find page 15. It doesn't talk about cotton. It's very specific. Synthetic yarn, man-made yarn, synthetic. Because as you know, silk and all, these are all not man-made. Naturally. Naturals. So these are synthetic filament yarn. So my case is very simple.
Wait. What about 5210?
This is composition of 80% cotton with man-made fibers. Man-made fibers, silk doesn't.
Or solely?
And polyester. Man-made fibers and weighing, the specification is also there. Because lordship, one thing is very important. My diversification of other products is always included. Because lordship will find that this was an argument made when in the Supreme Court in 1993, the Parloom went and they lost the case. Naturally, they lose the case. They say that our entire thing is gone because of the handloom. But the Supreme Court says handloom industry has to be protected. On that, you cannot come, but your diversification is possible. In fact, that is my case. I have diversified my product. Now, because of the order, you are putting a blanket ban. If you put a blanket ban, my right under 19(1)(g) and all, and is affected. And now the new doctrine, all Supreme Court has clarified it. Till the other years, the doctrine was that strict scrutiny will not be done because of the Wensbury's principle. But now the Supreme Court, I have a judgment of the Supreme Court, this has to go now. The court will have to apply strict scrutiny, and the margin of appreciation will be whether it is excessive or not, the rights are affected or not. If the rights are affected, it becomes excessive, the court can interfere. And earlier the question was hands off, if the policy matter will not do it. But now the Supreme Court, in the latest at the tedious. The proportionality doctrine is supposed to be the fourth principle, and by which the Wensbury's principle is gone now. Wensbury's talks about relevant and irrelevant. Supreme Court says no. If I may read that part. Lordship, the page 19. Here also what has happened in the land acquisition case, the Supreme Court intervened and said proportionally, the government's order, we are going to quash it because you have, Lordship will find this part, proportionally test. Paragraph 47 is the first case, Om Kumar. Lordship will come to paragraph 28. Can I read?
Yeah, going from one paragraph, say 48, 47, now 28. Which
47, I
paragraph?
have to refer to the Supreme Court.
Which paragraph do you want me to go?
I have to
going
refer
from.
to the Supreme Court judgment. The Supreme Court judgment is at paragraph 47, and the relevant part is at paragraph 28 below, what has they have given
28.
it at
Okay,
28.
now let me go to 28. Yes,
By proportionality, we mean the question.
28,
Para 47, Lordship.
47. Yes, okay, 47,
By
28.
proportion, yes, 47, Lordship is there. Down below is 27 and 28.
Yes,
28 I'm reading. By proportionality, we mean the question whether while regulating exercise of fundamental rights, the appropriate of least restrictive choice of measures has been taken by the legislature or the administrator. In my case, it is the administrator, so as to achieve the object of legislation of the purpose of the administrative order, as the case may be. Under the principle, the court will see that the legislature and the administrative authority maintain a proper balance between the adverse effect which the legislature or administrative order may have on the rights, liberties, interests of person, keeping in mind the purpose which they are intended to serve. The legislature and the administrative authorities are, however, given an area of discretion or a range of choice, but as to whether the choice made infringes the rights excessively or not is for the court. That is meant by proportionality. Now, this judgment of this proportionality doctrine has further been reiterated in paragraph 49, because the entire law on proportionality was laid down at page 21 in the famous Puttaswamy case, which is the law. 9 judges of the Supreme Court were talking about liberties, privacy. This court came in, if I may read, paragraph 49. Can I read? A 9-member bench of this court, while deciding the question as to whether the Constitution of India guarantees to each individual a fundamental right to privacy, expounded the principle of proportionality and legitimacy in relation to infringement of right as a result of state measures. I am effective now. It was held that proportionality is essential for protection from arbitrary state action, as it ensures that the nature and quality of the encroachment on the rights is in proportion for the purpose of law. While summarizing the aforesaid principle into a 4-pronged test, the bench held the action must be sanctioned by law. The proposed action must be necessary in a democratic society for a legitimate aim. The extent of such interference must be proportional to the need of such interference. There must be procedural guarantees against abuse of such interference. In my case, I don't come within, I know my limitation, because I cannot come within the handloom part. Handloom part, the government has full authority to go and expand it. It's laudable, but not at the cost of infringement of my right to do business under 19(1)(g). It's a fundamental right. Because now this blanket ban has been brought by the government, the officers, without backing up, without by legislation. Because as you know, Lordship knows, regulatory power is with the state, prohibitive power is not with the state. If the government wants to prohibit on anything, they have to bring a legislation. So my case is that since I don't come, I've shown it, and the diversification part, I can do it. Supreme Court in the Parvez Akhtar's case, that is the leading case of 1993, 2 SCC 221. It clearly says, which para? Para 64, it clearly says, you can diversify. And my case is, I have diversified. Para 64, 62, because there, Supreme Court rightly, I in fact support the case, because the handloom industry has to be protected. But the Supreme Court says, for business, which if you don't fall there, you can diversify and do your business, and there cannot be, that's my case. And now what has
but
happened?
why has the government taken this decision?
Well, how do I know?
No, why according
No,
to you?
according to the government from the
According
order,
to you?
my learned friend will be able to give, they specified.
I think you are well aware why they have done it.
I'm well aware of my case.
Only.
Yes. Well, so that is my case. And now what has happened? They are now trying to use penal powers. Well, this cannot be done. They have said, we will cease search. So at this point, we have come to refusal. So what I pray, Lordship, will call for the records. Well, I am ready, because the point of law is to be decided. He let them give the records, everything. And in the meantime, I need an interim protection. And I want that after the Bihu, let the matter be trashed out. Either I win or the state wins. I'm ready for with the, well, that is the only, in fact, para 62 is the relevant part, which can I read, Lordship, with your permission?
Just a minute.
Para 62 of that case, Parvez Akhtar, the handlooms are operated. Para 60. 62. It's a judgment by 3 judges of the Supreme Court.
Yes.
The handlooms are operated manually. The number of person employed in many times more than in power looms for production of similar qualities of cloth. The reservation of articles for handloom does not pose any serious threat to power loom. There the power loom came to the court. If it has been proved by the fact that even though the handloom reservation orders have been on the statute book since 1950, the power loom has continued to proliferate and there is no reason to believe that any of these looms are likely to be closed due to a reservation order. The power loom owners are only required to diversify their line of production so that they do not produce cloth reserved for handloom. That's my case. I've diversified. I don't come within the parameters, the legal specifications, the bar, which is there in table 11. And because of this order now, I have been totally, there's a blanket ban. It's an excessive disproportionate power exercised by the state, where the Lordship will exercise, in terms of the latest judgment of the Supreme Court, the power of strict scrutiny. Lordship, the margin of appreciation will be gone into, but the choices, though with the government, but they have exercised a power more than what they have. And there my rights under the 19(1)(g) is totally affected. It's a fundamental right, guaranteed right under the 19. In fact, the rules of 1985, the table covers the reasonable restriction. That power is always with the state. No one is disputing it, because that power must always be there. But here I feel, I say that it's an excessive power. And now they have exercised the penal power. The deputy commissioner has been told in all districts, you go, seize whenever you find this. So my thing is that, Lordship, I wanted that this entire matter be thrashed out after the holidays. And in the meantime, I want that protection. That is my prayer. I leave it to Lordship, subject to what?
Lordship, the whole purpose of this act is protection of articles.
Huh?
Protection of certain articles which are to be manufactured by handloom industry only. So I'll come to that. Now, his main thrust is that at page 14, paragraph 9.
Huh.
According to him, and he is a trader. If I'm not wrong, paragraph 1, he said he's a trader. So paragraph 9 says, the product that they are purchasing made and manufactured by power looms or selling under them to their vendors are of different composition. Lordship will kindly mark different composition and not within the ambit or range of the articles which specification is being mentioned in any range of products which are specified in the Handloom Textiles Act of 1985. The said fact is also fortified by the petitioner as the product code under which the goods are being produced and sold is under HSN code 5407, which makes the product distinct and different from any other range of products mentioned in the Act of 1985. The product under HSN code of GST has been mentioned as HSN 5407. Now, if we look at his documents, which he has annexed, Lordship will kindly come to page 37, Annexer C series. Here, the name of the product is not disclosed. Only the code. Why it is so? They have to give a clear indication what is the product. These codes are not easily discernible, or we cannot get the proper way unless he discloses it. Otherwise, we have to go to a scientific method. So the product name is missing. So he cannot take and rely upon this particular document at this stage before this honorable. Now, next, Lordship will kindly come page 38.
Name of the product, D number 1543 sets white. Then Chiku, then another 2 whites. So product is not disclosed. So they are suppressing something before this honorable court. Third one, the product is very clearly says Anchal Creations, product is chadar and mekhela. And if we go to the chart under the Act, Lordship, chadars and mekhelas will come. Page 53. That polyester thing he is trying to impress upon this honorable court that he comes under his products contains only polyester, no cotton, no silk. Page 53, Lordship.
Yes.
Yes, page 53. Now, 11, chadar, mekhela and fanek. Chadar, mekhela and fanek is used for covering lower part or upper part of the body and is manufactured from cotton yarn or silk yarn or earth silk yarn or in any combination thereof. So we have to know the exact composition of the product which he is buying. And it includes all kind of chadars. There is no exception. If Lordship is pleased to come to page number 50. In case of sari, there are some exceptions. In chadar, there is no exception. The whole article is protected for handloom industry. For sari, Lordship will kindly see serial number 1. Sari is a fabric made of out of 100% cotton yarn or 100% silk yarn or any combination thereof and includes a sari made in blends of or union of up to 45%, etc. Lordship will kindly come after 3, Roman 3, but does not include crepe, chiffon, sinon, gorgets, and cotton, voile sari, gray and beige. So certain class of saris are excluded. And if we look at the name of this act, Lordship will kindly come to page 44. We have to read the act as a whole. What is the overall objective intention of the legislature? An act to provide reservation for certain articles. Very clearly the articles is mentioned. So in case of chadar, the whole article is protected. In case of sari, certain class of saris are protected. So an act to provide for reservation for certain articles for exclusive production by handloom and for matters connected therewith. This act may be called Handloom Reservation of Articles for Production Act 1985. There is no definition of article here, but articles we can very easily discern from any law dictionary or general dictionary. Article means product. Now, Lordship will kindly come to section 3. Notwithstanding anything contained in the Industries Development and Regulation Act 1951, the central government may, if it is satisfied, after considering the recommendations made by it by the advisory committee, that it is necessary to do so for the protection and development of the handloom industry by order published in the official gazette, direct from time to time, that any article or class of articles shall, on from the date of may be specified in the order, be reserved for exclusive production by handloom. So chadar is exclusively protected for handloom. Section 4. The central government shall, with a view of determining the nature of any article or class of articles that may be reserved for exclusive production of handlooms, constitute an advisory committee. Section 5. Where an order has been made under Section 3 reserving any article or class of articles for exclusive production by handloom, such articles or class of articles shall not, on or from the date of reservations, be produced by any loom other than handloom. Proviso I'm not touching now. In terms of these lordships, the central government has given direction to the state government, section 16. Page 49, lordship. The central government may give such direction as may consider necessary to a state government as to carrying into execution of the provision of this act. And thereafter, this order under section 3 has been made, page 50, lordship. In exercise of the power conferred by subsection 1 of section 3 of the Handloom Reservation of Articles for Production Act 1985, and in supersession of the earlier order dated 26 July, except as respect things done and omitted to be done before such supersession, the central government being satisfied after considering the recommendations made by it, the advisory committee, that it is necessary to do so for protection and development of handloom industry, hereby directs that the articles of class of articles specified in column 2 of the table below shall be immediate effect be reserved for exclusive productions by handloom, the range specified in column 3, namely. So in sari, there are two categories. Certain categories are protected for handloom, certain categories it is in the open. For dhoti, it is exclusive. Whole article is protected. Towel and gamcha, serial number 3. There is no exception. Towel is a fabric woven in plain mat, twill, honeycomb, huckaback, or a combination of these weaves with border and heading, and includes towel made from cotton, etc. Last is B, gamcha. That is what we are concerned. But he is not disclosing whether that product code includes gamcha, sadar, or panek, or whatever. He is not coming up with clean hands before his honorable court. Now coming to 11, chadar. There is no exception. So sadar includes, sadar or mekhela or panek is used for covering lower part and upper part, etc. It includes puan of Mizoram, hara, jainsam, etc. of Meghalaya, skirts and udhana fabric of Nagaland and Arunachal, riha and pachara of Tripura, pawade, dhawani of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, Pondicherry, and dokhona, donka, khamlet, panek of Assam. These are exclusive products, without giving any indication that there can be some of these products which can be woven through polyester fabric or any other artificial fabric. It is not permitted. Whole article is protected. In case of sari, there is an exception. The Banarasi sari, the South Indian saris, certain saris are not included in this act. And the Supreme Court, while dealing with this act, how the Honorable Supreme Court held Parvez Akhtar's case, Lordship. The whole act was challenged. 1993, 2 Supreme Court cases, 221. Here, the whole act was challenged. Serial number 2, that's paragraph 2. The act and the impugn orders are violative of Article 14 and 19(1)(g) of the Constitution. According to them, there is a violation of 19(1)(g). They have not touched in the present writ proceedings Article 14. So 19(1)(g) is also covered. Paragraph 6, the restriction in this case are to be justified. It should be in public interest. Here, no public interest subset. These are the submissions. I'm skipping all this because today is not a full-length hearing. Paragraph 54. According to Krishnamani Learned Counsel, if there is a total reservation so as to create a monopoly, it would be bad in law. He relies upon certain decisions. This argument, in our opinion, proceeds on a misconception. There is no question of monopoly created in favor of handloom industry. Certain kinds of textiles, this is the opinion of the Honorable Supreme Court, Lordship. Certain kinds of textiles are reserved for the handloom industry. Still, there are a number of items available for powerloom owners which they can manufacture. The other class of saris and etc. The items of textile generally manufactured in the mills and powerloom sectors have been left out from the reserved items. Only those items which have traditionally been manufactured on handloom have been reserved for this sector. As a matter of fact, the reservation order in favor of handloom have been made on the statute book since 1950. But this has not deterred the growth of powerloom sector in the last 3 decades. Recently, when the powerloom started producing the items which are traditionally being manufactured on handloom, that caused a serious inroad into the handloom industry. The result was an unequal competition for the handloom sector. If, as rightly pointed out in the counter affidavit by the Union of India.
I think we'll have a proper hearing.
Lordship.
Very
interesting case,
But no
Lordship.
stay,
Interesting. Malad,
No
at
stay.
least the punitive part maybe because,
no stay.
and one
Heavily
counter I
tilted
want to
in
make,
favor
one
of the
counter I
active
want to
industry,
make. Submission was made, which is not the correct position. I don't deal in gamocha. So that thing of suppression of whether it's Gamucha is not there. And secondly, Lordship, the Guwahati High Court in a similar matter, a coordinate bench has held that you cannot exclude other products from the purview. Well, I have annexed that. Para 75 of the page 75. That ground also I have taken. The Guwahati High Court has
No,
dealt.
we'll see all that, but right now,
These are not
I'm-
perishable goods, Lordship.
I'm not inclined.
Your Lordship, I cannot ask for a blanket stay on the first day, but at least the punitive part may be stable. Some
What
product-
is the punitive? What?
Well,
what punitive action?
the order says that punitive actions now will be taken. Well, that part may be still.
Punitive action in what?
Regarding,
In what
because
case?
section 8 or 10, they are going to invoke the penal provision. Well, that cannot happen. Well, we as citizens have some.
Where?
Page 70. No, 8 not. The penal provision of here. Well, the order itself specifies, this is an order because the Handloom, now the deputy commissioner has directed everyone. Page 54. Look, they cannot prejudge the thing when the matter is, well, a judicial review has to be given some, their order is not sacrosanct. Straight away you bring the penal provision to bring fear. Where is it? Page 54, Lordship. Otherwise appropriate action will be taken according to the law, and the penal provision is that.
What is the action taken?
No, Malad, search and seizure power is there in the act. Malad, your Lordship knows that the arbitrary power has been controlled only by the judiciary. There's no other institution. Malad, since your matter is being heard, I'm not asking for, I know my limitation. I'm not asking for a blanket stay. The state, let us complete. I'm ready for hearing. But
What
at
do you,
least some
no,
protection.
penal, they have to take some action. Some action has to be taken.
Malad, Sam,
What action are you?
What I
happy
want, since
of?
your matter, and the Lordship is issuing notice
Oh.
and fixing the matter, because your Lordship will have to fix the matter for final disposal. Because this cannot drag on, because I'm not
Correct,
getting an
correct,
interim on the first day.
Correct, correct.
I'm ready also. So at least the provisions, the letters, section 10, they cannot invoke the
Section 10?
page 47 is section 10, the penal provision, search and seizure and imprisonment for 6 months. These provisions cannot be invoked till the matter is decided. That protection I will definitely can ask. Lordship. Coercive action,
Page?
page 47, section 10. Whoever commits, whenever producer of class or articles in contravention of the orders may, because they have already issued the order of penal provision also.
No, you
So
see,
he is not a producer.
you
first of all.
see,
He's not
that
a
is what,
producer.
you're not a producer.
No, but we-
All your invoices
No,
are
no, what
only,
has happened,
you're
we have
purchasing.
been- What has happened because of the order now, we have been refrained from selling. We are not, we are coming to the court for adjudication of our rights. Your Lordship is now not giving an interim protection, that I do agree, but at least coercive action till the matter is decided, because I am ready for the final hearing also.
Don't take any penal action against
Yes,
them.
that part.
No,
why not?
Lordship, penal action cannot be taken overnight.
Correct.
No,
There is a
fair.
process, whatever the deputy.
No,
commissioner-
penal action, I mean,
Please.
don't, no
Yeah.
criminal case should be initiated against them.
It is
Unless
not,
you are a producer, that's all.
you are not a producer. Our
But
officers
training
are
has
that
been
much
refrained.
sensitive.
Malad, we fear that since
They
the
fear
deputy
because they are doing
commissioner's
something
order.
which is not
We'll
permissible in law.
clarify that, we'll clarify that, the section 10 cannot apply unless they are producers or manufacturers. That's all.
Yes, that will
No,
suffice.
Lordship,
That
may
will
not be,
suffice.
because that will give a wrong impression.
No, there is no question
No,
of wrong
first,
impression. The matter
paragraph
is-
of-
Unless they are producers or manufacturers.
No, Lordship will kindly see.
Ah.
Because in the garb of what they are coming before, they are not very clear. Paragraph,
Malanda, hearing there, I'll be clear. There I might not be clear.
my friend is
After hearing
over
that,
anxious.
Yeah,
The tiffin time is over, he is
Yes,
over
sir.
anxious.
you can't
This
help it.
protection is always given by learned friend also.
No, I don't agree to this.
Malanda, yes, as an additional, as an advocate
Lordship-
general, he will not agree, but he as a counsel will also, has been practicing.
Let me
also.
hear him. He wants to, he wants to clarify some doubt I have. Let it,
Yes,
you
but-
have got to give him some privilege. He's the AG.
No, I'm not stopping him from arguing.
So prima facie Lordship will not issue a order which is, does not have, carries any meaning.
Huh,
Paragraph 3, 4, 5, everywhere he has written.
huh.
He has invested huge sum of money in infra, etc. and selling and trading.
Selling and
everywhere he
trading.
is writing selling and trading. Any common person with minimum knowledge of law will understand who is a trader, who is a seller, and who is a manufacturer.
Okay, right.
We are not saying we are manufacturing. These are the orders which we get it. We are before this
Lordship,
board, Lordship.
That
This is not our first time.
You know what I'm reminded of? A leopard can't change his spots.
something is not disclosed before this honorable.
So I was just finding it humorous,
Why not?
you keep on arguing all the time.
The judicial processes, some sort of humor is always required. It's good for our health.
Anyway, right, heard Mr. D.K. Das, learned counsel for the petitioner, who submits that the petitioner is engaged in the business of trading of varieties of textile cloths, including mekla chadar, having different composition, which are also produced by power loom with man-made filament. So, the petitioner's counsel submits that the petitioner purchases products manufactured by power looms for selling them to their vendors, the composition of which are not within the ambit of articles whose specifications are being mentioned in any range of products specified under the Handloom (Reservation of Articles for Production) Act, 1985, hereinafter referred to as the 1985 Act. The petitioner's counsel has relied upon the various invoices to show that the goods which he has purchased pertains to HSN code number 5407, which is exempted from the 1985 Act. So he also submits that the petitioner purchases products under the HSN code 5210, which is also exempted under the 1985 Act. As such, the petitioner should be allowed to continue to do his business with regard to the products that he is buying and which do not come under the 1985 Act, as otherwise his right under Article 19(1)(g) will be violated. Mr. D. Saikya, the learned AG, on the other hand, has submitted that the invoices annexed to the writ petition do not show the products which the petitioner is buying, while there is a specific bar of articles, the specific bar on specific articles in the 1985 Act. He submits that the chadar, mekhala, and fanek are articles which are to be made under the 1985 Act, besides gamocha, etc. On considering the prayer for an interim order, this court is not inclined to grant any interim order at this stage. However, so we'll fix a date,
Yes, Lordship.
uh,
In the
Issue-
first week of May, Lordship.
issue notice.
Yes, we'll file a
Notice on
petition.
interim lordship, then on the next day,
Huh?
notice lordship. or
Issue notice
lordship-
returnable in 2 weeks.
2 weeks.
Mr. Dinath or who? Mr. Who accept?
3 weeks. Well, then let it be 3 weeks, but with the beginning.
Anyone?
Mr. Thar,
Mr. Ardhar accepts notice on behalf of
the state respondents.
state respondents, while Mr. Dinath accepts notice on behalf of 5. Mr. S. Roy accepts notice on behalf of respondent number 1. 3 weeks, no? I said, list the matter on. What date? You tell me. You give me a date, petitioner.
3rd or 4th of May, Lordship.
Let it be on third lordship. Third lordship.
Third is here.
4th is a Thursday.
Fourth, my lord.
We fix a lot.
Then Lordship, maybe
Some force-
9th of May.
Some
If it is-
non-positive. Some non-positive protection from the court. That as a
That
lawyer,
will
I
send
can
a wrong
also-
message in my humble
No,
submission,
no,
Lordship.
because we are ready for.
Because
No, we have
These are
said, we have
unscrupulous
said,
business
we have
person.
said that you are selling and you are a trader.
On the first day, if a petition is moved and a submission is made, that we are unscrupulous and all, then virtually today only the matter can be decided. Lordship can discuss
Yes.
my petition.
it can be decided. I can argue on law.
Well, I can also argue on law. And the second half, only second half, I won't be.
So both of you won't be here, I'll be here.
I'll be here, Lordship. I'll make myself available.
Well,
For the
there
sake of the handloom
non-coercive
industry.
part, Lordship, because your Lordship is fixing for final hearing. I am not getting an interim
No,
protection.
no,
That I
no,
can.
you see, this no coercive can be interpreted in too many ways.
Well,
Yes.
the deputy commissioner himself says that
Deputy Commissioner, that line is very clear, Lordship, that
the violators, well, I have been refrained
as
now.
per law,
They might, well, as per law, if
The deputy
everything
commissioner,
was
sir-
as per law, no one would have approached the court.
otherwise appropriate action will be taken
Yes.
according to the law.
And they
We
have
cannot
said that,
violate law. This
yes,
is
and
a
they-
language.
Malat, and imprisonment for 6 months, which fine, Malat, are they threatening us?
He is
It is written-
just like that on the very first day somebody will be hanged.
No, that will clarify, it will take time.
Malat, at
6
least-
months, no, 6 months, Dave.
Malat,
6 months.
yes, Malat.
The trial
is
is
a bailable-
5 years.
Malat, Lordship will at least specify that.
Huh?
That thing I can always ask for. Because I am not asking for a
Okay,
stay.
just write, list the matter on when,
4th or 9th.
4th of May.
4th.
Yes,
or list the matter on 4th.
till then.
Till then,
Lordship, that will create a big problem, Lordship.
criminal case should not be registered.
No, no, we are not going to do, Lordship.
You know, don't do.
We are not going to do. How
Okay.
can we do, Lordship? We have to follow a certain process, seizure process. That will not accompanied by arrest. It's never done like that. And we are not going to, we want to protect the handloom industry. As simple as that.
I've got a meeting.
Yes, Lordship.
Anyway,
Your
so,
Lordship will pass the order.
Nobody, seizure will
lawyers
not
can always-
accompany the arrest.
Lordship will take the final call.
we'll record your undertaking
Yes.
that you will not.
Whatever action, penal action we take, it will be properly as per the provisions of the law. There is no scope of arrest there.
That may be recorded.
There is no scope of arrest.
There's no scope of arrest. So we'll.
I have a notification. In fact, if he wants that protection, he will have to challenge another notification where there is a direction for seizure of 2015.
No, seizure is okay.
Yes,
I
there is
don't want the arrest, no arrest, that's all.
Cooperate, Balot. We are
Not,
cooperative. We are
Lordship,
coming
we cannot violate the law. Otherwise the officer will be hauled up. by
Seizure
the
so
solid
you can
report.
do. Seizure and all you can
Yeah,
do.
but
other body.
Lordship,
Only that
why
arrest.
is he apprehending arrest?
I don't know.
That is the
Balot,
problem.
because he has
That
already
means
said
they are-
that
they are hiding law.
because I am apprehending arrest because he has already said I am
Then let him
I am
go
an
to
unscrupulous
438.
person.
There's a provision called 438 under CRPC. He can take an anticipatory. plea.
Malad, your Lordship will record
he's
that
so
because this
apprehensive.
part, yeah, the power of finality is only with the court, not with the councils. So Lordship will take.
438 is provision is there. If somebody is
This is the
apprehending
judicial
arrest, they
system
can go
we
to the
I will see.
criminal court.
I will see. I've got no time now.
Deeply obliged.
Your Lordship will. Obliged.
While disposing of the earlier list petition, they have undertaken that they will take the fishery for the 31st of March 2023. Only that point the
Where is, where is
No,
that?
that,
in the order,
that is
in the
regarding the
petition also there is
earlier,
a-
my lord. Earlier, there was an extension, my lord.
Just a
Annexure
minute.
Lordship,
B, my
Lordship,
lord.
Lordship, kindly go to page number 59, Lordship. Lordship's order, this is.
At page 20 is the earlier extension, my lord.
Lordship, mentioned. later that
23, my lord.
Till 31st, as the prayer of petition is unable to run the fishery
In
till
fact,
31st.
the
Page
Was
process is
extended,
not
already
yet-
extended.
Page
Already
number
extended.
60, Lordship.
Huh?
Page number 60, Lordship.
Just a minute.
Page number 60, Lordship. There is no question of extending, Lordship. They
That
have
is
already
regarding the,
taken
earlier
fishery for
petition.
8 years, Lord. 7+1. It's a 60 page number.
Just a minute. So it was already extended up to 23 of this.
Month. This year,
So,
Lord.
my lord, now, my lord,
No.
Page,
Page 60, Lordship.
page 60, yes.
that is,
Six
my
zero.
lord, during the, my lord,
Yes,
their
60.
period of extension and NIT was issued, then and the petitioner challenged that NIT and ultimately that was cancelled. That is a different issue.
No, now what is your case?
Here, my lord, the petitioner was given a, kindly see page 23, my lord. Earlier, there was an extension was given to the petitioner.
Just a
Uh,
minute, just a minute.
Yes, my lord. Page 23.
Yes, it's 23.
Page 20, this is an extension order, my lord.
Yes,
Extension was given for 3 years, that is up to 31st March 2023. my
so
lord.
that's finished.
Yes, my lord.
No.
My lord, thereafter what happened, my lord, the private respondents, they filed a case, title suit against the petitioner, and they have trespassed into a part of the fishery of the petitioner, my lord. They are not allowing the petitioner to fish in that part, my lord. The proceeding is going on, my lord. I have annexed the plaint, my lord. So,
That is between you and the.
there is, my lord, because of that, my lord,
Which case, which page?
page, my lord. Annexure. K, page 61 to 75, my lord. This title suit is pending, my lord.
So?
They have also obtained injunction. They are not allowing the petitioner to enter into his own fishery. That is why he is unable to fish and he is suffering from financial loss, my lord. So because of this, he has, my lord, submitted various complaints he submitted before the, my lord, authority, my lord. He has also submitted a representation at annexure, my lord, L, page 76, my lord. That is under consideration there. That is pending, my lord, not yet disposed of. That is dated
That if they want
21,
to, if they want to decide that, they will decide.
Yes, my lord.
That depends upon them. They have got no right to remain. heard Ms. S.B. Chowdhury,
On the
learned
ground of
counsel for the
financial matter-
petitioner.
My lord, there is a
Who
provision
submit-
for
who
extension, my
submit
lord, in case of
the
financial, my
petitioner.
lord, loss, my lord. Section Rule 6, of the
Dismiss.
financial.
Next. Dismiss. Heard Mr.
P. Sharma.
P. Sharma for the respondent number
Eight dissolution.
APS. Respondent number?
Post of,
My lord, the
What's his- he is
respondents
for-
may
he is for
consider
respondent number one,
dispose of the representation, my lord. That is pending, my lord. My lord, the representation is pending, my lord. Let them dispose of the representation.
For the respondent number? Mr. K. Gogoi for respondent number 1 and Mr.
P. Sharma.
P. Sharma for respondent number?
Two and three. Two, 3, 4.
2, 3, 4.
For 1 and 5 lordship, deputy.
1 and 5, K. Gogoi, 1 and 5. Huh? Next.
My lord, the direction may be given to the dispose of the
Ma'am, they give for-
representation, my lord.
My lord,
That is pending, my lord.
Take up suspension, no complaint. Yes, Mr. Counsel, yes, what is your case?
My lord, as per Land Acquisition Act, the respondent number 5, 6, and 8 have not followed the rules and law properly. As per provision laid down under section 4.
What has happened to your land? What has happened to your land? Are you landholders?
Yes, my lord.
You have got what, Jamabandi or what have you got?
I have Jamabandi copies and also the revenue payment receipt, but I could not annex to the repetition because voluminous in nature, so I could not.
Voluminous in nature.
So I may be permitted to file additional affidavit. I have mentioned in my para, my lord.
Where, which para?
In my para number, my lord. Para third, my lord. Para number third, that the petitioners further state that they are the inhabitants of villages Murara, Milanpur, Kasare, Holmari, ward number 8.
No, where is, I thought you'll give pata number and this number and dog number, nothing is.
My lord, against my name, already the respondent number 5, the deputy commissioner concerned for Kamrup Amingao has prepared against the tag number and button number,
Where?
annexure number, my lord. Fifty-six, 59 page, my lord, annexure 5.
Where is your name?
Collectively, we are 17 numbers, my lord, not single person.
Tell me where is your name? How many, petitioner number 1, where is his name?
Petitioner number. What's the petition? I'm sorry. My humble submission is this, since I have also a plot of land nearby the proposed route, which is going to be enlarged and expanded under Assam Mela. I have been affected.
Where is your
And
point of, Mr. Counsel, can you understand the question?
my lord,
What is the question?
question is this, whether my name is inserted in the annexure as I have shown before this honorable court. But
More than
particularly-
that, where is your land document?
Oh, yes, my
First
lord.
of all, your name is not here. Secondly, where is your land document?
My lord, in compliance to the notice served upon me, I have made representation along with other petitioners. And all about those facts narrated in our petitions. That petition has not been considered. Objection has not been considered, my lord.
You first show this court that you are the owner of your land. Show me your land document.
In this particular respect, I have been, I may be allowed to file additional affidavit because I have inserted in my para if it is required.
You have said nothing in your para. You have only said that you are owner of the land. You have not mentioned any
My lord,
periodic pata, dark number,
no,
what is the area? Nothing has been mentioned.
not only single person, my lord, your honor. Not only I am the single person, there are so many persons.
I agree.
Yeah.
You see, none of you all have mentioned any land document. And forget about one person. None of you all have mentioned.
Yes, madam.
Then,
I have mentioned in my para number 3, specifically Jamabandi copy and the
yes,
related
what to
revenue
do,
payment
Mr.
receipt
Nayak?
is recorded in Assamese language.
Mr. Nayak,
My lord.
what is to be done?
What if, I'm actually trying to find out what is his grievance clause.
That is what, really correct.
He
You are correct.
against a proposed survey lordship for
Huh?
acquiring a certain portion of land lot. First thing, he is unable to show this honorable court which particular part belongs to
Correct.
his lot. That is first thought.
He's no document. I am dismissing your writ
My
petition.
lord, I may be permitted. Kindly, I have been, I may be considered, my lord, for my negligence or neglect on the part of myself.
You withdraw with liberty to file a fresh, we'll give you.
That may
There is
be.
no case otherwise.
No, it may be permitted, my lord, because I shall file additional affidavit.
You will not file anything, I know. You have got no case. Okay, right, heard. What is your name?
MS Ali, my lord.
M.
MS Ali.
M.S. Ali, Learned Counsel for the petitioner. I am dismissing your case because there is nothing in your favor in this case.
My lord, I may be permitted to withdraw along with liberty to file a fresh.
There is no case. You have got no case. You see your prayer. See your prayer. Please read your prayer.
Under the above facts and circumstances, it is therefore felt that this honorable court may be pleased to admit this petition, issue a rule calling upon the respondents to show first causes as to why a writ in the nature of certiorari and or in the nature of writ or the direction of like nature should not be issued, declaring the proposed survey and acquisition of land for extension of Rongi and Nagarjuli Road under Assam Mela to be illegal, unfair, injudicious, arbitrary, discriminatory, unconstitutional, and inequity. Directing or commanding the respondent authorities not to act upon the present survey and consequent proposal to acquire the land of the petitioner. And or further be pleased to pay adequate, reasonable, and fair compensation as that of others. And or upon cause or causes have been shown thereafter, hearing the parties may further be pleased to make the rule absolute and or be pleased to pass any other order as this honorable court may deem it and proclaim.
So what do you want actually in this writ petition? What are you actually praying for?
My lord, we are in evidence nearby the proposed road, which to be enlarged and extended. And we shall be affected if the road is extended or enlarged without the following norms, procedure, etc.
So you want compensation?
Not only compensation, my lord, my requirement is this also, the road should be extended, taking the measurement from the middle of the road. up to the each of the is it?
They will do that
Yes.
then.
Why, but that has not been done by the concerned respondent authorities.
Lordship, what I have understood, Lordship, most probably has his land, Lordship, his plot of land
No, not only my land.
has not been acquired or it.
No, it's not been acquired. You see, there is going to be a proposed survey.
Yeah.
There's going to be a survey done on the land. On the land, because his road, his land is near the road.
Yes.
So there's going to be a proposed survey.
No, Lordship, he is claiming that if the road is measured from the middle of the road, then his plot of land will come
Ah,
under the road.
Correct,
Lordship.
correct.
But as the authority is taking another road, Lordship, his
Ah.
land is not under that proposed road, Lordship.
Oh.
That is his grievance.
So he wants his land to be acquired.
Yes,
Oh,
he is paying.
but he's praying otherwise. He's praying that, he's praying for setting aside that proposed survey
But his basic grievance is.
and
that
the
he is not-
acquisition.
land has not been
No, my lord. Actually, the road which to be enlarged, nearby the road, we have the land,
existing road.
existing road, but that road to be enlarged and expanded.
So,
And this is.
so why
this
do
is
you want
being-
to, why do you want to set aside the proposed survey and acquisition?
No, my lord, my prayer before this honorable court to direct the concerned authorities to make the measurement properly, survey the land properly, and without any discrimination. But that has been done with discrimination.
No right of yours is
Kindly-
affected.
Lordship, may kindly see the synopsis, Lordship. One line is there, the lot mandals of their villages took measurement at of proposed acquired land illegally, discriminately and zigzag manner as they are being managed by some interested persons for which their land are kept.
Okay,
Unmeasured.
okay,
So
okay,
his land has not been measured. That is his grievance. Lord.
okay.
My lord,
Yes. No, actually, I did not read all your prayer. You see, your prayer contradicts itself also. Okay, you withdraw. Heard, Mister?
MD MS Ali,
Learned counsel for the petitioner to plead that he may be allowed to withdraw the writ petition
with
With-
liberty to fight.
with liberty to file a plea.
Yes.
Mr. P. Naik appears for
PWD Lordship,
PWD
1, 4 and 7.
1, 4 and 7, comma, Mr. K. Gogoi appears for
5, 6 and 8.
5, 6 and 8, comma, Miss S.R. Raba appears for Miss G. Hazarika appears for point number 2 and Mr. S.R. Raba appears for 8. You draft it properly and you please put in your land document. There's nothing here.
I am sorry.
Your 17 petitioners, none of you have put anything. Huh?
That's why, so very short time, that's why I could not make all the related papers.
The lot mandals are making the road in a zigzag manner, planning zigzag manner. Your writ petition is also in a zigzag manner.
My lord,
Should be-
but
It should go from point A to
actually-
point B in a straight line.
as per the provision laid down under section 5.
Okay, the
subsection A.
petitions council is allowed. Writ petition is dismissed as withdrawn, comma, with liberty as paid.
Right, Lord.
Your present.
I have the instructions, my lord, that that permit was given for my lord's government works. For construction of my lord houses under PMGSY, Pradhan Mantri, my lord, some Awas Yojana. AYG. And my lord, for that, request was received from my lord, the engineer, BDO, and the DC. And following the due process matter, mining plan, environmental clearance is there.
Have you given a copy to the other
I
side?
can give.
Lordship, in my humble submission, let them come with an affidavit because rule 5, sub-rule 2 requires,
Rule 3 is rule 23, subject to rule 5, madam.
yes, Lordship, but rule 5, sub-rule 2 requires that the contractors engaged for the works, projects of the government department, agencies shall be granted mining permit.
You file the affidavit,
Yes,
small
Lordship,
affidavit,
because
Yes.
we'll list it again.
this knowledge is
Yes,
contract,
yes, madam, this
This
has been
permit
deliberated, madam, many decisions, madam. I'll file in short affidavit.
this
Sure.
permit holder is not
Yes,
engaged for the specific project, Lordship, that is shown.
So
in-
let him file an affidavit.
Yes, Lordship, that.
And apart from that, my state has a monopoly, my lord, in minerals, madam.
I know, no,
Yes.
no, that is, I'm not on that. You just give us affidavit.
Yes, yes.
Yes,
That's
Lordship.
it.
Let them come with an
Yes.
affidavit.
When will you file?
I just need a short time. After view vacation, it will. it
You
will
will
come
be some
before.
Lordship, otherwise term will be.
No, no, madam. Wait and sir. New season is arriving, my lord. Land will be, the area will be again by filled by sand.
Okay, what date do you want? Give a date.
Any date in the month of April after vacation, Bihu
Okay.
vacation also.
Let it have on my lord 11th,
11,
11th of this month.
Mr. D. Gogoi, learned, learned counsel for the forest department submits that he will file an affidavit. In terms of the order dated 3/4/2023. List the matter on 19/4.
Yes. How late?
अब लाइए।
Lordship in item 12, Lordship, I have some instruction, Lordship may like to go through the instruction one.
Item,
Item number 12, Lordship.
So that is regarding the, it has come the other day, my lord.
The firm,
Your Heart Medical College, my lord, they were not making.
yes.
yes, Lordship. Lordship may just go through the, I'll.
Can I have a copy?
Have you given a copy?
Lordship, I will just give. my
Please give
copy.
it to you.
Yes.
But my outstanding is 5 crores. But
all
here the
that is-
government is party, DM is party and the principal is
Lordship,
also party.
Regarding the arrear
Let all of
salary
them,
also, the
Malad bhai.
government is taking steps. For that, I need some time, Lordship. The arrear also will be paid.
Let
Till
notice
Ma-
be issued, my lord. And they must.
Till
respond.
March, Lordship, the government is only taking responsibility for the payment. And pursuant to the petitioner has a agreement till August, my lords. So that period from April to August, my lords, the hospital management society is also going to take up the responsibility. So the petitioners can rest assured that their money will be paid. As per the instructions, that is, it just some time is required, my lords, because the current budget session has just lapsed, my lord. That's the thing.
So March, when will you pay this 23 lakhs?
So, Lordship, here, that is what is being considered. Recently, they have been paid an arrear amount in February only amounting to 2 crores, my lords. So,
It's arrears. You see, your submission would have been considered in the proper perspective if you had given advance or something. Yeah, arrears, you have.
arrear,
You
Lordship,
have
we
to
are
pay.
making the payments in installment, my Lordship. It's a huge amount, Lordship. So, some sanctions.
It's a huge amount naturally, but then you see, they have got to pay their workers, everything. Those sweepers, they're not earning lakhs of rupees.
No, Lordship.
Sweepers will be earning a few thousands.
Lordship, that is under consideration, Lordship. The main, Lordship, the main grievance of the petitioner is whether or not and how the payment that has been resolved, and we have explained how we are going to pay. Because initially, the main contention was that the government has refused to.
You have not been paid your money from March 22.
Madam.
Correct. So from March 22, you are going to pay.
Yes, Lord, that will be paid by the government and.
From March 22 to
To March 23, my lords.
March
uh,
23.
Yes, that has been assured, and pursuant to that, there is a hospital management committee, my lord, that has been formed. They will pay the remaining amount, my lords. That has been. assured.
Monthly,
Lordship,
monthly.
lordship, for that, lordship, 2 weeks, let some time maybe allow it, my lord, so that we can come up with, that is what is under consideration, my lords.
Right. Mr. A. Chaliha,
Lordship,
Learned Counsel for the
Health Department, lordship.
Health Department submits that as per instructions received by him. The arrears, arrear payment to be made to the petitioner from March 22 to March 23 would have to be paid by the, would be paid by the government of Assam. So if the government does not release fund for the year 2023-24, the JMC authority will make necessary arrangement for payment of the petitioner's bills from the month of April 2023.
April to August, my lord.
Huh?
April to August, that is. the
April
tenure-
2023 to August
that is the
2023.
tenure of the-
He submits that he needs further instructions with regard to when payment for April. For
Regarding all the payment, the
Right,
outstanding dues.
Madam, let some areas be paid, let him instruct.
Lordship, that
some part of the
maybe
area.
during the pendency, my lords, it might be done also.
Wait a
We are
minute.
not- is under
we'll obtain further instructions as to when payment can be made to the petitioner.
Lordship,
List the matter on.
Lordship, after 3 weeks, Lordship. In the meantime, Lordship, if any payment can be done, that will be done so also, my lord. It's not, pendency will not be a bar, my lord.
28 April.
28th April, Lord.
Madam, let them say this in affidavit also, Lord.
Lordship will file a. Right
Yes,
now it will be premature.
Mr. A. Chaliha shall also submit
Right now,
an affidavit.
Lordship, like, let us get a
Within-
more detailed instruction, my lords. This won't suffice.
No, it's just that you admit to the liability. He wants that
Lordship, we'll furnish the necessary instructions.
by the next date.
Lordship.
Same date. By the next date. What is this?
Lordship, in this matter, the petitioner had participated in a settlement process initiated by the Assam State Transport Corporation for settlement of shops at the transport plaza to be proposed to be constructed at Silchar, Your Lordship. So he emerged successful, paid the amounts required, Your Lordship. From 2018 onwards, not even a brick has been laid at the site, Your Lordship. The photographs are there, Your Lordship.
And money has been given.
Money has been given.
How much money has been given?
Presently, the total amount he has paid is 3,43,846. That amount.
Oh, so this is going to be the proposed site. This is the proposed site.
This is the proposed site. Now, if they cannot complete the building, at least they should return us.
Who is the authority to whom you have given the money?
The Assam State Transport Corporation.
You must probably paid the area salary and pension of some employees.
I heard I am appearing on behalf of my senior Mr. Jero. He is in ICU, my lord. Some time may be given for instruction.
Otherwise, if your lordship issues a short notice, let them
We'll
come back
issue a
with the
notice.
instructions. Can be disposed of.
You have to pay back the amount.
Notice may be.
But was there any agreement?
Yes,
That you
in fact,
signed?
if your lordship turns to page number 30, your lordship,
Yes.
there was a demand from them to pay the amount, your lordship.
No, but when were they supposed to complete the building?
No completion time was there. But from 2017, your lordship, it has to be reasonable, your lordship. In the tender per se, there is no completion time. In the work order,
Okay. Right, heard Mr. KP Pathak, learned counsel for the petitioner, who submits that the petitioner participated in the settlement process initiated by the respondent number
2, 3, and 4.
2, 3, and 4. Wide NIQ dated 15/7/2017 for leasing of commercial stall/shop spaces in the ground floor of a proposed transport plaza at Flag Station, Assam. State Transport Corporation, Silchar. Synopsis. Synopsis. On emerging successful in the settlement process, the petitioner was allotted stall/room number 7 by letter dated 4/5/2018. The petitioner paid the total amount of rupees 3,43,846 towards the said allotment. However, even though more than 4 years have elapsed, not one brick has been laid by the ASTC for construction of the transport plaza till date. The petitioner's counsel submits that the petitioner had submitted a representation dated 4/5, no,
No, your lordship. It-
2018,
No,
13.
no.
It's 23/7/2021.
23/7/2021 to the respondent number 2.
This is one number 2. Yeah.
Respondent number 2. To either deliver possession of the stall/room number 7 or refund the money deposited along with interest. Full stop. However, no action has been taken by the respondents till date. This is 4/5/2018, I think.
No, lordship, that is the reference number of his allotment number.
Okay.
The date is at the bottom of the page.
Okay, 23/7/2020. Yes. full stop. Issue notice returnable in 3 weeks. Mr.
D does.
D does accept notice on behalf of the respondents number 2, 3, and 4.
That's spam for one.
While Ms. MD Bora accept notice on behalf of point number 1.
Fine.
List the matter on
That's my fixed it.
May, my lord, in the month of May.
May. Give May, first week, second week, anytime.
Fine.
Public.
Deeply.
Keep your obliged.
How is he? How is Mr. J. Roy?
My lord, he is improving, my lord.
What was the problem?
My lord, he got stroke, my lord, mild stroke,
Mild stroke.
my lord. Blood clot is there, my lord, in brain,
Where? In the brain.
my lord.
And what is to be done?
Treatment is going on, my lord. He is doing fine, my lord.
Okay. How old is he?
Around 55, my lord.
Okay. Looks healthy, I don't know.
My lord.
I don't know.
They will not be even arguing that case.
Huh?
During an